Mention only the extremely urgent matters. I'll start from one side. Yeah. Yes, please continue.
This is a matter where the parts had some sharp angle. The parts engage the contractors.
Day after tomorrow talk. Day after tomorrow talk. Please handle.
In respect of Chauffeur's notice given to me, I will be proceeded against for fraud without giving me a single document on the basis of which the chauffeur's notice is issued.
Mr. Shorter, not right.
But if the time expires tomorrow,
not right.
But it is going to appear tomorrow, that's the returnable date if my kindly indulged.
No, Mr. Shorter, no, sir.
But it is severe consequence.
Follow duty extreme notice or by accident. Incident. To I claim the damage of the insurance company.
No, no. Afterwards. Yes.
We have to find the water being
Yes.
Mention an application only for inclusion of an application after vacation.
Please come back after the vacation. No, not right.
Yes.
Well, the last 5 years,
Wait, what is the urgency? What was it?
Not even
No, no. After the vacation. No, not right. You are an advocate. Please wait for the advocates. After that, I'll take up your. Yes, next. No. What is that, please? Take the microphone. Take the microphone.
Some medical device is required to run by the electricity. He is very serious. His brother is very serious.
Hand over. Talk tomorrow.
This is covered by judgment.
What is this? What is the matter?
Non-disbursement of fixed.
Come back after the vacation. Not right. No. Yes, Mrs. Hod, yes. Not right. After the vacation.
For auction only on 30 and the date of auction is 28. And in the meantime, notice would have been by coordinate bench order notice. I have allowed to deposit rupees 30 lakhs in the bank and I have deposited it. But in spite of that, the auction notice.
We will day after tomorrow talk.
It's not mine for anyone of part. I have been educated and got an assignment card.
Come back after the vacation. Please come back after the vacation. No. Next. Mr. Hazaman, you are not there. You came from behind. Yes.
CDCL disconnected my electricity connection and
I got upgraded here. I had upgraded. Application come back after the vacation. Yes. No. Come back. After vacation. After vacation. No. After vacation. Yes. Come back after the vacation. No, I cannot add more matters. Come back after the vacation. Yes. Extension.
card and TP card has been deactivated without giving any opportunity of
Day after tomorrow talk. Yes. Cannot add any more matters. So many matters already there. I'm telling you. No. Cannot add. Sorry, 86 upgrade ones. Sorry, no further addition of tender matters. Yes.
Yes. Railway tender was granted partly to L3. I am L1. And the other part will be granted either tomorrow or day after.
Sir, I cannot add further tender matters. Sorry, there are too many matters, sir.
work order, construction of the involved such a habitual clause, which is absolutely
In the matters, I cannot add further.
extreme margin that is above the declare.
No.
Which is
No, sorry, no. Yes.
And electricity connection also is connected.
Come back after vacation. Come back after vacation. No further addition. Yes, no further addition. No. No. Mr. Mondal, no. Yes.
You are the father of the master. We have filed a complaint case before the respective council. They are not listed in the investigation.
Come back after the vacation. This can wait till after the vacation.
Kindly pay that charge for this.
No. Come back after the vacation. Yes. Mr. Zaman, I cannot add any further matter now. No. Yes, you. The ladies. Pardon, I couldn't hear you.
But we supposed to file on 9th of January. LOC has been issued against him.
Come back after the vacation. Immediately after the vacation. Come back after the vacation. Yes.
It is a new connection matter. As compared to what format.
No, no, after the vacation. Yes.
Application for beginning of an expiry order, because the matter was updated the notice to me.
After vacation.
Application, I thought.
Mr. Chaudhary.
Filing the application today, paying for district day after tomorrow, section 95 of the IBC manner. Personal guarantor, notice has been given on 8th or 22nd, this will lapse and lordship goes by the IRP automatic. Absolute violation of.
Hand over day after tomorrow.
The
Stop.
district file in course of the day.
Very good. Very good. Yes.
The father and the uncle of the petitioner were shaped rather than after the death of the father, your petitioner got the and
What do you want now?
application matter.
Not right now. Yes. Pardon it. Be louder. After the vacation. I cannot hear these matters before the vacation. Yes. Be louder, please. No, come back after the vacation. Come back after the vacation. Yes. From that. Come back after the vacation. Come back after the vacation. Yes. Not right now.
Returned to your own liquor shop has been closed below on the 11th. Lord, citing that I have not applied for subscription of teaching.
No, no, you come back after the vacation. These matters can very well wait after. No, liquor shop can wait after the vacation. Sorry.
I did not have 167 of days.
Yes, what is that?
My father has petrol pump. And year expire. He could expire. He made him pay. But I keep I covered everything. And what I have come from 24 again. The Indian will notice.
Not right now. Yes. আপনি অ্যাডভোকেটদের আগে শুনে নি তারপর আপনাদের ইয়েস
Application in the list, I, as a petitioner, I served ambulance services to the hospital during the.
মানি ক্লেম আফটার ভ্যাকেশন ইয়েস
Stuck in the trunk accounts because of the actions of the respondent.
মানি ক্লেম আফটার দ্য
It could be taken.
নো ক্যানট ইয়েস I can't hear you. Please use the microphone. Termination of after vacation.
In my shop, I'm the only trader. Until 168, kindly.
Hand over day after tomorrow. Yes.
Disconnection for the last 6 months.
6 months you can wait till after the vacation.
The source also come.
I appreciate, but 6 months you have wait for some. Not right. No, not right. Yes.
Last year, I mentioned that the date on 15th December. Today the date for removal of alleged stalls.
What stalls? Who are you? The stall owners? Hand over tomorrow. I think. Yes. No. Come back after the vacation. Yes. Non-prosecution handover. Yes, sir.
Yes, that for two packaging. It is able to, it is for the packaging. then entire route will be shut down. It shut down because the particular machines are only for
What are you challenging here?
that Indian stand. That's certain because it will affect 2.5 lakh workers and very
Very well. Tomorrow it will appear at the top of the table. Yes. Please. Yes. Come back after the vacation. You can wait till after the vacation. Yes.
Subdivision includes the audited survey of has rejected the application by us. Bank of section 14 of the Subsidy Act.
Come back after the vacation. Yes.
So, because,
Bank has no urgency in section 14. What are you saying? Yes.
I was of the information I was of information when these matter 1 March I'm without
Come back after the vacation. I cannot add any further matters in update. Yes. Contemplate, please come back after the vacation. Yes. Very well. What is the urgency?
Sir, registration certificate of the medical company being if I been cancelled and there was
Wait for something.
on the other side.
Wait for something. Yes. Yes, sir.
Against the restrictions for participation in the process during the payments of the repayments 596 of the I've been during the payments of the repayments I have been
No, come back after the vacation.
but it's out of open my
No. Yes.
without water.
Yes.
So that was updated the matter. It was supposed to come up more.
You're seeing the reason from the model.
But I don't really have pleasure to appear in the update category. Is that here?
If it's already appearing in the update list, it will. Yes. Yes. Wait for some time. Yes. When does it expire? Hello. Yes, Mr. Sinha, what do you want?
My lord, municipal matter, my lord, order has been already suppressing the division order.
Come back after the vacation.
My lord, any day between-
No day. After vacation.
What has been obtained, the
Mr. Sinha, not before vacation. Yes.
stay on bank but stay the bank is not allowing to release the funds.
What are you by profession?
I am a business.
Wait for some time. Yes.
Because the lawsuit said 8 and 9 are numbers, but the same issues appearing on this is the lead matter being to be typed with those matters 8 and 9. Today's topic is this with regard to whether the chairperson of the adjudicating authority.
Let us see what happens in 8 and 9. Then we'll decide.
Leave me not to file it,
What?
under the same issue, is
No, 8 and 9 I'll decide first.
well, the gross irregularity in school, where is the students?
This has to be decided on merit. Come back after the vacation. No. Yes. Cannot. No time. 5 days left. If it's a money claim, please wait for after the vacation. Yes. I'm only refusing. Sorry, not right. Go before the tribunal, not right. Not right. You have a remedy there also, you know. You mentioned it there a few minutes back. I said no to you. Why are you mentioning again? You're just wasting time, sir. I told you no. Why are you mentioning again? My memory is so short, I'll even forget within a few minutes you mentioned. Don't repeat. Yes. Not right. Yes.
Commission dealing with the bank, where my agency has been blocked legally. I have a house loan. in respect of the-
Come back after the vacation. Cannot take up physically, not possible to take up so many vacation.
Very short.
No, no. Right now, you cannot write. You see, after the vacation, please come back. We'll consider it. No, not right. Yes. Tender matter, I cannot add any further. 86 matters are there. Let me hear this one. No, ma'am. Let this mention. Yes. What is your mention? আপনার অ্যাডভোকেট কেউ অ্যাপিয়ার করছেন না, তাহলে আপনি কেন মেনশন করছেন? আপনার রাইটই নেই মেনশন। আপনার অ্যাডভোকেট কে? আপনার অ্যাডভোকেট আপনাকে পাঠিয়ে দিচ্ছি। রিফিউজড স্যার। Why did you send her?
Lordship, I have already advised him many times, but since so many months have passed, he wants to appear in person. So
No, refused. No, she's there. Yes, আপনি আসুন। কি বন্ধ হয়ে গেছে? মেইনটেনেন্স। হ্যাঁ। এখন কি চ্যালেঞ্জ করেছেন?
আমি 127 ওনারা করেছে ডিক্রিজ করার জন্য আমার একটা আরটিআই করেছিল ইনফরমেশনের জায়গাটা খুব হওয়া দরকার সেজন্য আরটিআই
আপনার লিস্টে আছে ম্যাটার? আপনার কে উকিল বাবু আছেন?
কিন্তু উনি করেছেন আমি পাচ্ছি না ওই জন্য বাধ্য হয়ে আমার কোনো এভিডেন্স থেকে চলে গেছে আমার মানে ফাইন্যান্স থেকে চলে গেছে
উকিল বাবুকে কালকে নিয়ে আসুন। কালকে নিয়ে এসে মেনশন করেন, বলুন জজ সাহেব বলেছেন ওনাকে নিয়ে আসতে। আপনি আসুন, ওনাকে নিয়ে আসুন। কালকেও যদি উনি না আসতে চান আপনি মেনশন করবেন, তখন আমি নিয়ে নেব। না, ওনাকে বলুন জজ সাহেব ডাইরেকশন দিয়েছে উনি যেন আসেন আপনার সাথে। কে আপনার উকিল? ওর নাম কি? নাম জানুন, ভালো করে খোঁজ নিন, ওনাকে নিয়ে কালকে আসবেন এখানে, বলবেন জজ সাহেব বলেছে আপনাকে নিয়ে আসুন। ইয়েস। No, you have been refused. Yes. No, I've taken up all the advocates mentioning. Now I'll take up the sorry. We cannot go on forever. Yes.
for that, number one,
WPA 3963 of 2023 is disposed of by directing the Respondent number 2 Central Warehousing Corporation and its chairman to disburse the following amounts to the petitioner for work done by the petitioner's father under the CWC Nimpura Kharagpur head in terms of the reminder dated September 2, 2022, annexed at page 193. The components I have directed is security money, 43 lakh and odd, bills for February, March, April, that 38 lakh block, supervision charges, 61 lakh block, invoice numbers, 5 lakh 62, casual labor charges to the tune of 158,823. Total comes to 1 crore 50 lakh 86,724. The last what I have not given is the 13 lakh component and the balance of this 3 lakh component for casual labor charges. The last component above for casual labor charges to the tune of rupees 1,58,823 shall be paid subject to the petitioner producing proof of GST payment for such amount. Payments as enumerated above shall be disbursed by the respondent 2 and 3 in favor of the petitioner as expeditiously as possible, positively by January 31, 2020. January 31 is set because they need a chance to go up in it. Can one dispose of accordingly? No rest.
But I think that time charges. Like when it's your case. I can proceedings keeps saying.
Let me just say. I have recorded that the CWC has admitted 1,50,000. Petitioner has agreed to such payment for the time being on such condition. But you getting 13 lakh. Let me just say. Yes, I have kept it open. Hence, insofar as the component of 13 lakh such and such is concerned, it is kept open for the petitioner to claim such amount by way of regular civil suit. That is in paragraph 22 of this chapter. No.
for that one, item number 2.
Sorry, a WPA 26230 of 2020 is dismissed on contest without any orders to cost. At this juncture, a stay of the operation of the order is prayed for. However, since the writ petition has been dismissed, no useful purpose would be served if an order of stay of operation is passed, since the same would not automatically entail that the reliefs are granted in favor of the petition. Accordingly, such prayer is refused. Next. এটা add হয়ে যাবে তারপর again please. No thought was. So file a written notes, otherwise I'll close up. You are for the right? Yes, fine. You are appearing for whom?
The district judge.
Will, you also filed during the course of the. You are for the petitioner. You have to file a written note. So file it during the course of the. Written notes have been filed.
Yes. Only one thing is missed. Regulation of 2020.
I won't remember. How can I remember? The judgment will be after the case. Won't remember. It is pointed out by Ms. Porna Roy Chaudhary that her name was erroneously recorded in the order dated December 14, 2023 as appealing for the state, whereas she is appealing for respondent number 7, that is the concerned district judge. Let such error begin to stand corrected automatically. Next para. The written notes of arguments filed by the petitioner, the respondent number 5, as well as the respondent number 6 today be kept on record. On the period of learned counsel for the respondent number 7, the respondent number 7 is directed to file their written notes of argument during the course of the day. Arguments are concluded, judgment is reserved. But I'll pass my judgment after the vacation. I cannot do it before the vacation. I don't have time. Therefore, yes, please. Please give half of it. Yes. It was recorded wrongly in my order. That's why it has been sent by the department. It appears from a note dated December 15, 2023, given by the department that the cause title of the matter has been erroneously typed in the order dated November 17, 2023. Accordingly, let the order dated November 17, 2023 be read to incorporate, in place of within W noted the additional district magistrate as others, W noted close as recorded therein, to be recorded as State of West Bengal and others. Let's this order be deemed to be a part of the said order. Next. In part, what is the correction? Oh, January 15. The returnable date was mentioned erroneously as December 15, 2024 instead of January 15, 2024. In paragraph number 12 of the order dated December 7, 2023, let such error be deemed to stand corrected and the matter be next placed for hearing in the list on January 15, 2024. Sorry, yes. Next. Yes, sir. What is the matter about? Be short, yes.
Yes, very short. Don't be troubled by the people. It's already covered.
What is the matter? Yes.
Well, there is a tender that gets floated for supply to particular railway. So, no agency floats. 80% is given to X
20% is given to Y, which is now after it's awarded, the letter of acceptance alters three terms and conditions. I'll show those. The 80% tender was successful, challenge is given by a detailed, elaborate order. It is found by the court, interim state, but very elaborate. I'll show that. It's found that there are two clauses which are at least in departure in the LOA from the tender clause. And then the law is concerned about how tender conditions, if it deviates, are not liable. And then there is a stay, because what happens is post the tender, they go ahead, post LOA, other zonal railways start issuing all these work orders. And if I don't comply with it, then there is a penal action that I'm liable. So there is a stay on them from proceeding any further with regard to the 80% work order. That point. And the 20%. So more importantly, with regard to that, there is no appeal that's been preferred. They have not even filed their affidavits in that.
Show me that interim order first.
Yes. According to the first page, just to highlight the challenge.
Yes.
According to learned counsel appearing for the petitioner, the tender term incorporated in the notice inviting tender sponsor was on the basis of the petitioner's agreed to participate, letter of acceptance. However, this is important. However, states at least two clauses of the special and general clause of the contract which were a part of the NIT dated 20th October 2021. Of the two clauses, the petitioner, this is important, particularly agreed by clause I, which introduces the commencement of delivery period within 3 months of issue of contract. Counsel submit the petitioner may not have participated in the said tender had the petitioner been aware of the changes which were inserted later. Learned counsel appealing to the respondent authority submits that the petitioners have come to court at the belated stage and the petitioners have failed to supply the liners despite 6 months having elapsed from the issuance of the letter of acceptance. Upon consideration of documents placed before the court on behalf of the parties, it is apparent that clause 5I, an additional term, was introduced in a letter of acceptance dated 17 March 2022, which is not part of the NIT. A tender is an invitation to offer, which in this case was made on 20th October 2021, persuading the petitioner to participate in the tender. The petitioner's participation may be seen as accepting an offer which was audited on 17 March 2022.
So, Banerjee, has there been any further hearing of this matter?
No.
Affidavits exchanged?
No. Not filed, not preferred appeal. I was only on 2 points, same challenge, same fact.
One is the commencement of the delivery. 3 months.
Period changes. Where they say 24 months, their commencement has to start within 3 months.
Yes.
So it's unclear, and that is considered here. This clause was under consideration. So I was on 2 points. One is this position having been accepted even at the identity state of the respondent. There can't be a change of stance here. Second, on committee of courts, we're on the same fact, same clause.
Yes, I'll grant a similar order regarding this 20% and you file your opposition. I'll hear both the petitions together and decide.
My instruction is they use certification.
But this order stands in your face. I mean, stares in your teeth. I cannot pass a contrary order unless I vacate this order, which I cannot in a different petition. This binds you. Even interim orders bind you unless set aside or vacated. That is the difficulty against you right now. That is why the only course of action which I can see for you, because obviously it's a public project, Railways has to take the point that it cannot be stalled for long. So how soon can you file your opposition? I'll direct these two matters to appear together and hear out.
My instruction is there is no certification. Whatever the agreement signed, we will not go beyond that.
You will not go beyond the agreement.
No, my brother.
So you won't give effect to the. So you have to issue a fresh letter of intent in terms of the tender. If you do that, the petition becomes.
Agreement is addressed, my lord.
Show me.
Both the parties signed. We shall not go beyond that.
But this position has been accepted by the court or by a coordinate variance.
But something, my lord, that was not this before that issue, my lord, at that time.
Maybe, but you have not filed any vacating. You have not challenged this order. So this has attained finality against you. This was passed in September, November, December.
He is alleging that there is a deviation. My submission is there is no deviation.
I'll record that, but I'll comment on it. I have to replace. I'll definitely. Learned counsel for the petitioner contends that in terms of a particular tender, letters of intent were issued to the petitioner as well as another bidder. The percentage of work issued in favor of the petitioner was 20% roughly, whereas the other bidder was given 80% of the work. Is support in the context in respect of the 80% bidder, a challenge was preferred subsequently to the letters of intent issued to the said bidder as well as the petitioner, which allegedly deviate on three important. এটা এখান থেকে আসছে তাহলে শব্দ আছে দেখো on three important counts. Next para. Learned counsel for the petitioner submits that in connection with the challenge preferred by the 80% bidder in WPA 20114 of 2022, coordinated bench of this court, video order dated September 8, 2022, was prior satisfied with the case of the petitioner and granted an order restraining the Eastern Railways as well as the other respondents from proceeding any further with the tender or the purchase orders issued on the petitioners. Next para. Since the letters of intent and are similar and the tender process is also the same, learned counsel for the petitioner argues that in the absence of any challenge to the said order, although the same is an interlocutory one, the same position ought to be maintained at least till pleadings are exchanged in connection with the lead petition. Next parallel counsel appearing for the Eastern Railways vehemently opposes the prayer and argues that certain documents were not placed before the coordinate bench while the order was passed. It is further disputed that there is a deviation from the original tender clauses. Next para, be that as it may, it is seen that the order of the single judge was passed on September 8, 2022, and till date, neither the same has been challenged in any appeal nor any application for vacating has been filed or any order passed there. Thus, even at an interlocutory stage, unless a gross change of circumstances is shown, the ratio laid down in the same order of the coordinate bench is binding on this court. I do not find any reason to deviate from the same, since if the Eastern Railway was of the opinion that the court was not presented with certain relevant documents, it was always open to the Eastern Railway to take recourse to Order 39/4 of the Code of Civil Procedure. Be that as it may, the respondent shall file their affidavits in opposition. How soon can you do that? How soon can you file your opposition? Within January 19, 2024, reply if any shall be filed by January 31, 2024. The matter be placed for hearing in the monthly list of February 2024. There shall be none. The respondent shall remain restrained from proceeding any further with the tender or the purchase orders issued on the petitioners, in line with order dated September 8, 2022, passed in WPA 20114 of 2022, until further orders. WPA 20114 of 2022 shall be listed along with this petition when the matter is next listed for hearing. How can I direct them? Why didn't you file a vacating application of Justice Bhattacharya? I could have taken that up. And you are taking 4 weeks to file opposition. Forgetful. Railways won't be grateful to you for that. I was expecting a much lesser time. Anyways, let us come. Yes. Yes, what is the matter, Mr. Thara?
I and my learned senior friend had gone there. However, the situation arose.
Just let me just brush up the memory. What was the order? What was your case? Just remind me.
84 to both parts. It is that matter where I as an elderly have.
Oh, your documents are there.
Yes, now your lordship, a peculiar situation arose over there, which both I and my learned senior friend had to face. Is that kindly comes to the last order, paragraph 9.
Yes.
It states that keeping the question of maintainability open, the petitioner is directed to go to the disputed property at 84 Tubot Park, PS Vazoni, such and such, on December 16, along with his learned friend. Now, a primary objection came from respondent number 7 and 8 to the effect that this order states that he can go to the police, but this order has not directed them to allow him entry into the aforesaid rooms for inspection or for identification.
On that ground, you are refused.
No. Your lordship, what had happened was the applicant was standing outside. However, I, along with my learned senior friend, have entered.
Your learned senior friend is Mr. Chatterjee. This time it will be him alone. Yes.
So you
Because of his client's conduct.
So your lordship, so
Ultimately, you got the things.
your lordship, the main issue is that the keys which were supplied to me by my client, it was not fitting in the almirahs which were shown to us, and the rooms that were shown to us, I could only look at the articles in those rooms. However, having said that, I have on instructions that at least in the future, if there arises any claims, there should not be any impediment for it to be settled at least.
Do you want to continue with the repetition? Then I'll direct it to its file, or otherwise, if you want to take back the matter, I'll make that clear. And no, let him come. Let him come. Yes. Do you want to proceed with the repetition or not? I mean, I'm asking you. No, this is not lordship.
This particular
Be fast because others are waiting.
this scenario, your lordship, as your lordship has. I
won't direct
I
it.
am willing to go ahead with the application, your lordship. However, it's up to your lordship.
Your entire repetition was on this. Let us see.
Yes, my entire read was on this, that since the ownership in the last occasion, since the ownership.
Then you have to go to the civil court, Mr.
Yes, exactly. your
I'll
lordship.
give that liberty, Mr. Chatterjee. Yes, whatever you say. Say.
House has been sold. 2 sons and 1 daughter. They are residing over
They're not
there.
parties here.
1 son and daughter-in-law is the party. The name of daughter-in-law property was not sold. That has explained. It has fallen from your lordship to deliver photo frame and medical documents. Photo frame was delivered myself along with my friends. We both entered into the room. We have searched all the almirahs. In thereafter, once
And direct a joint photo of you and your learned friend to be taken and put in that.
thereafter, the person was not happy. He said there were some books, there were some documents.
Obviously, he's not happy.
My God, he already filed on section 94 application in the court below for search warrant under section 200 of criminal procedure code in the month of January 2023. That was allowed, but he did not appear in the court below. Thereafter, it was dismissed for default for non-appearance in the court below. Now, when it has come before your lordship with a writ application, my lord, whatever we have.
I'll give him liberty to canvass his rights in a civil. It cannot be done by it. Learned counsel for the parties submit that when the petitioner went to the premises along with his counsel, learned counsel approached the concerned almirahs, but those could not be opened with the key provided by the petitioner by his counsel. Push up next para. Accordingly, it transpires that the petitioner apostrophes claims to the documents allegedly lying in the almirahs cannot immediately be resolved. Next para. There also arises the question as to the title of the petitioner in the movables lying in the property in question. Next para. Learned counsel for the respondent number 7 and 8 also raises the issue as to non-joinder of other necessary co-owners of the property to the present petition. Learned counsel for the respondent number 7 and 8 also argues that previously a search warrant was issued at the behest of the petitioner, but the petitioner did not further appear in the matter for which the same was dismissed for default. Accordingly, the present writ petition is a reiteration of the same claim which ought not to be entertained. Next para. Be that as it may, since the petitioner's remedies with regard to the right title and interest in the movable properties lying in the immovable properties in question, comma, the appropriate remedy of the petitioner is not before the writ court or the criminal court, but before the competent civil court. So accordingly, WPA 26347 of 2020 is disposed of, with liberty to the petitioner to approach the competent civil court having jurisdiction to ventilate his grievances and seek appropriate reliefs with regard to the movable properties lying at the premises in question. If so approached, comma, the said court will decide the same independently and in accordance with law without being influenced in any prejudiced in any manner by any of the observations made here. No rest to cause certain.
Almirah was open.
Almirah was open.
Almirah's open, locker open. Kind of
Almirah was opened by the keys of the respondents because the keys supplied.
আচ্ছা একটু মাধববাবু আসুন একবার
So there is
যেখানটা বলেছি দেখুন প্রথম সেন্টেন্সে পড়ুন ভেরি ফার্স্ট সেন্টেন্স
Concern Almirah, but it could not be opened with the keys provided by the petitioner.
full stop. The Almirah's comma, however, comma, were ultimately opened with keys furnished by the private respondent number 7 and 8. This much?
only 7 euros.
Private respondent number 7. Bas, बाकी जाएगा. Yes. Yes, Mr. Kaur.
There is a provisional attachment order which has been sent for confirmation to the adjudicating authority under the PMS.
Yes.
Now, the adjudicating authority at the present moment does not consist of a chair. It's just a single member who is not according to his appointment, it's to only look into the commercial matter. I'll show the appointment letter. But look, before that, may I just show your lordship note the provisional attachment first, and look the show cause notice that is issued. Rather, look, like take your lordship straight to the show cause notice that is issued. Please come 368. Rather, page 363. 363 is the show cause.
Which period you said you won't proceed?
That is good. So far as the provisional attachment order is concerned, I am not challenging it on merits because that has to not come up at the stage of adjudication because that order has been properly issued in compliance with law.
So then what are you
I'm
showing me now?
saying that the person who is issued this show cause
Yes.
does not have jurisdiction under the PM. That's the short.
Very well.
Because Lord, I am aware of the fact that your lordship has already held in a judgment
Yes.
that Lord, the single member can.
Have you got the PML?
Yes.
কোনটা বলুন তো? Okay, I've got it. Sorry. Finish.
May I just briefly tell your lordship what the facts are? Why Lord, I am being issued this show cause notice?
Yes.
Because Lord, I have obtained a loan
Yes.
from a company called SABYASACHI Infrastructure Finance Limited,
Right.
which is a non-banking financial company. And Lord, they say that SABYASACHI has not received certain sums from certain persons which they were not supposed to receive. And this is a case of money laundering in that sense. And their case is that the loan that has been given to me, out of which I have purchased the property in Maharashtra, that is affected by that. The
Proceeds of that.
proceeds of that.
Right.
That is how not because I have obtained an infrastructure loan, there is no dispute.
But if it's proceeds of crime, probably they can.
That is the
Right.
crux of the matter against me.
Right.
That's how the notice, show cause notice has been issued. The
Yes.
show cause notice is at 63.
This is
Lordship will find that it is sent to me, and Lord, your Lordships will find that the third paragraph, your Lordships will find that this is the notice.
Yes.
That I am supposed to indicate the source of income, etc.
right.
So this is the order is not annexed to this show cause notice, starts at page 364
Yes.
to 368. And note the person 379 fourth view. Yes.
71.
362.
Oh, no, 68.
368.
Yes.
Kindly see the last paragraph, paragraph 11.
All right.
This is how it is framed, and the person who has signed it is signed it as member finance.
Please show me from the from the act.
So, look, your lordship may kindly straight away come to first note section 6, the adjudicating order.
Yes.
The central government shall by notification appoint an adjudicating authority to exercise jurisdiction powers and authority conferred by under this act. Then adjudicating authority shall consist of a chairperson and 2 other members.
Yes. Yes.
Then provided that one member shall be a person having experience in the field of law, administration, finance, or accounts. Then a person shall, however, not be qualified for appointment as a member of the adjudicating authority in the field of law unless he is qualified for appointment as district judge, etc. And we are not really concerned with those. Then, Lord, please come to 4. The central government shall appoint a member to the chairperson of the adjudicating authority. Then 5. Subject to the provisions of this act, the jurisdiction of the adjudicating authority may be exercised by the benches there. A bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members as the chairperson of the adjudicating authority may deem fit. Then the benches of the adjudicating authority shall ordinarily sit at daily, etc. Then the central government shall by notification specify the area in relation to which each bench of the adjudicating authority may exercise jurisdiction. Then Lord, please come to 6. Notwithstanding anything contained in subsection 5, the chairperson may transfer a member from one bench to another. Then, if at any stage of the hearing or matter it appears to the chairperson or a member that the case or a matter is of such nature, it is by a bench consisting of 2 members, the case or matter may be transferred by the chairperson, or as the case may be referred to him for transfer to such bench as chairperson. So, Lord, basically, Lord, chairperson is the master of the case.
So by default, Mr. Code, apparently it appears that it should be 1. If required, it will be referred to 2.
It will be referred to 2.
It may be 1.
Maybe.
And it will refer to 2
Yes.
members. But it has to be authorized by the chairperson.
But
that is the only requirement.
that is the only requirement. And Lord, what it seems, the scheme of the act, it at least not my understanding is that chairperson is the master of the case.
Yes.
So Lord, he would decide who would hear what.
Right.
And Lord, of course, Lord, I find that central government can by notification specify the area also. That your lordship.
That is not a constitution of the bench actually, the area of
area of
functioning.
the transaction.
That is a bit different.
Really,
Yes.
really not the subject matter.
PMLA comes.
Yes. Now, Lord,
Yes.
the question today is that the person who is there is a single member. He is not the chair.
But he's authorized. If he's authorized by the chairperson, then your challenge goes.
There has to be a chairperson to authorize.
But there is no chairperson.
There is no chairperson. Absolutely not headless. I mean, at the present moment.
But there are several persons who actually commit crime. They'll go scot-free during this period.
But
May not be your plan.
it's not a question of adjudication. It's a question of who can take cognizance.
Yes.
For the purpose of issuance of the show cause. But in my humble reading of section 6,
Yes, you are apparently correct. Subject to what she said.
and Lord, this is principally the ground. And Lord, we say that the matter that my Lord had vision to deal with, that RP Infosys Systems judgment. But I think the judgment is with your lordship.
Yes, you handed over.
Look, this is a case where the chairperson was there. The other members were not.
There I turned down the objection.
Yes. Your
Because the
lordship,
chairperson was.
yes. Your lordship's finding, your lordship will find in paragraph 26, 29 and 30. 26, 29 and 30.
Yes.
The lordship held that there is a chairperson.
That was the premise. Right.
That, because not one or more. It can
There is no chairperson now.
and
Yes.
there is an order passed by the Delhi High Court, I find, on 25th of August 2023. This this focus notice was issued in November. This is an order passed by Delhi High Court. Yes.
This says no chairperson is there.
No chairperson is there. But I don't think not my learned friend will
Obviously, this is on fact.
because not if the chairperson is there.
This is not the chairperson. She probably won't.
And he can blame himself to be the chairperson. And not if there is a chairperson, then not lordship judgment will hold up. Then I have no case. And in fact, not I find this gentleman who has been appointed as a member of this is not screenshot of the K. Upadhyay has joined as member at
Let me hear Ms. Ray on this.
Yes, but just one thing, I have taken another point, which if your lordships kindly take section 8.
Yes.
Once.
Yes, section
8.1.
8.1.
We are at the stage of 8.1.
Hmm.
On receipt of a notice under subsection 5, section 5, or application made under subsection 4, or under subsection such as if the adjudicating authority has reason to believe that any person has committed an offence under section 3 or in possession of proceeds of crime, it may serve a notice of not less than 30 days on such person calling on him to indicate the source of his income, earning of assets, out of which, etc. The evidence on which he relies and the other relevant information particulars have to show cause why all or any such property should not be declared to be the properties. This is the state at which now, the question is, there are certain legal issues which is required to be considered for the purpose of making issuing the show cause. But these factors has been taken into consideration in a Telangana judgment. And Telangana High Court has held that the member has to be a judicial because he has to consider the issues which arise out of the legal issues that arise. But this is the issues which arise for consideration are really not twofold. One is whether there is an offence committed under section 3 and the whether or not he is in possession of the proceeds of crime. And this is the Telangana High Court judgment. The lordships may kindly come to page 39. Okay. Just 2 minutes. Issue number 2, paragraph 11, and then straight away come to page 98. But after discussion, after the full discussion, paragraph 20 and 21 are the concluding. These are the 2 points that are.
Now, what has to be there? You were saying something has some ingredients have to be there.
Yes, the ingredients are section 8.1. Subsection 1.
Reason to believe that any person has committed an offence under section 3 or in possession of procedure of crime. This much is there in this section.
These are the 2 considerations
yes,
that one has to apply. And what Telangana High Court says that these are judicial mind is necessary for this.
For that purpose.
For that purpose. Your lordships may kindly
very good.
Paragraph 20, Roman 20 at page 98.
Yes. Field of law is mandatory.
These are the two points that I should
Great.
and
Yes. Yes, Mr. What is that?
item 9, which is identical.
Acha, yes.
I will pay for petition. But with one additional point,
Same petition.
everything is same except the name of the
Same officer. Same member.
same member, everything same. Same
There are a number of loans that has been paid by various parties. So we are issuing this notice to all the persons.
Naturally, yes. Yes, Mr. What is your additional point?
additional point is
We waited.
Rule, yes.
while having this same rule, see, 2020
Regulations.
rules, 2013 Act is 177. Which it is
The
the,
book is not the same.
I'll give.
What is the regulation of which year?
2013 rules of
Rules of 25 years of got. Which
issuance of
rule?
provisional attachment order rules 20.
Which rule?
Issuance of
Rule number?
number is
There are only 4, 5.
2013.
I've got it.
oh,
Yes.
then
What is the provision?
rule 3.
Yes.
Manner of issuance of provisional attachment order where the director or any officer
Right.
authorized in his behalf as business to believe on the basis of materials in his possession. For the proceeds of crime or the property involved in money laundering has to be provisionally attached. The said officer shall make a provisional order. Then your kind take your approach. The authorized officer shall endorse a copy of the provisional attachment order to all concerned, including the persons in possession of the properties and the adjudicating. Now, this forwarding to the adjudicating authority by the authorized officer method in our submission method has not been done subject to further amendments.
But that is a challenge to the action of the ED authorized officer, not the executing authority. But that I don't have determination, Mr. If you take that point, then I'll have to relegate it to the other ones. No, don't.
No,
I can send it to the other ones.
I recollect the last location this is what was guided
Because it was specifically mentioned, a point was taken by Ms. Red. This was the specific ground on which I assumed determination that this is not being checked.
But this will in any event come up for adjudication. When finally it is.
Yes, that all
That
points you can do. Yes, Mr. Red, very short point, yes. Not judicial member, more importantly, chairperson is not there who will authorize.
It's section 6.
Yes,
subsection
14, right?
where a chairperson of the adjudicating is unable to discharge his function owing to absence, illness, or any other cause. The senior most member shall discharge the functions of the chairperson of the adjudicating authority until the date the chairperson of the adjudicating authority resumes his duty. So whether I think that is absent, it's not been appointed, it's absent.
Mr. Red, there is no issue. Need not be the chairperson who issues this order. But he has to be the person, has to be authorized by the chairperson. It's not a question of absence of chair. Physically, chairperson may not issue the order. Somebody else will. But chairperson has to authorize. Here, there is no chairperson in chair. So, who will authorize? How can there be an authorization under section 65B? It's a question of authorization, not the passing of the order. Definitely, a single member who is an administrative member can also pass, subject to Telangana High Court. That right. I'll have to consider. But there has been authorization. If there is no chairperson in the chair, who will authorize? He cannot delegate his function of constituting the bench. That is what I have said. No, don't come.
No, madam, because
It's a question of law.
authorization you have with us, madam. That is the difficulty.
Oh, you say there may be an authorization. I'll record your order, but please don't proceed on the basis of this show.
Madam,
Tomorrow don't proceed.
Yeah, but that is already recorded.
Whereas senior counsel has made out a strong prima facie case as to the order dated, impugned show cause notice dated November 2, 2023, being without jurisdiction, comma, since a single administrative member, comma, who is now functioning as the adjudicating authority alone, comma, has issued the same. Full stop. Learned Senior Counsel places reliance on Section 6 within bracket 5 within bracket small p of the Prevention of Money Laundering Act 2002, which provides that a bench may be constituted by the chairperson of the adjudicating authority with one or two members as the chairperson of the adjudicating authority may deem fit. Sir, it is contended that in the present case, comma, there could not have been any authorization by the chairperson, comma, since there is no functioning chairman at present of the adjudicating authority. Full stop. Next para. It is further argued by placing reliance on an unreported judgment of the Telangana High Court in the matter of Messrs. Hygro, HYGRO, Chemicals, Pharmatech, TEK, Private Limited versus Union of India and another, that the learned single judge of the Telangana High Court observed that in view of the exercise to be performed under Section 8 of the PMLA Act 2002, comma, the member who issues the show cause notice is required to be a judicial member. Full stop. Next paragraph. Learned counsel appearing for the Enforcement Directorate places reliance on subsection 14 of Section 6 of the 2002 Act.
Very sorry. Time comes to 10.
10. Yes.
If for reasons other than temporary absence, any vacancy offers in the office of the chairperson or any of the members, then the central government shall appoint another person in accordance with the provisions of this act to fill the vacancy, and the proceedings may be continued before the adjudicating authority from the state on which the vacancy is. So whether
Vacancy has to be filled in the first place to proceed from that stage.
this person, that I will produce. That I will.
You produce what?
But what the central government has nominated.
No, this vacancy is on a higher footing. The chairperson has to be appointed.
Yes, but
the vacancy means the vacancy of the chairperson.
So the person who is
you are disputing that there is no chairperson. That also you are disputing. Is there any chairperson?
My knowledge is there is no chairperson.
This vacancy speaks about chairperson's vacancy. So once the vacancy is filled up, then only it can proceed from that stage.
Yes.
How is this relevant at all?
Well, maybe the person is authorized. That is what I'm saying.
Subsection 14 of Section 6 of the said Act of the PML Act 2002 and argues that in terms of the said provision, comma, when the chairperson of the adjudicating authority is unable to discharge his functions owing to absence, comma, illness or any other cause, comma, the senior-most member shall discharge the functions of the chairperson of the adjudicating authority until the date on which the chairperson of the adjudicating authority resumes his duties. Whose next para? Learned counsel also places reliance on subsection 10 of Section 6, which provides that if for reasons other than temporary absence, comma, any vacancy occurs in the office of the chairperson or any other member, comma, then the central government shall appoint another person in accordance with the provisions of this act to fill the vacancy, and the proceedings may be continued before the adjudicating authority from the stage at which the vacancy is filled. Who's the next para? Please don't disturb. No. I'm nothing like that. No. Learned counsel. Please don't disturb the court, Ms. Rai. You have to know the limit. No. Not during passing of orders. Definitely not. However, comma, none of the said provisions pertain to the instant case at all. Full stop. Insofar as sub-rule 14 is concerned, comma, the same envisages a temporary absence of the chairperson of the adjudicating authority owing to absence, comma, illness or any other cause of similar nature. Full stop. Next para. Subsection 14, however, has nothing to do with section 5 within bracket small b and the constitution of the bench as envisaged there. Full stop. Section 6 within bracket 5 within bracket small b provides that the chairperson may constitute a bench which power cannot be delegated to someone else. Full stop. Next para. Hence, subsection 14 operates in a different field than that of section 5 within bracket, subsection 5 within bracket small b. Full stop. Subsection 10, on the other hand, merely provides that if there is a vacancy other than a temporary absence in the office of the chairman or any other member, when a new appointment is made, the proceeding shall be carried on from the stage at which the vacancy is filled, which also has nothing to do with the present dispute. Full stop. Next paragraph. Yes, Mr. What do you want? 13 years. But finish now, once and for all. This is not a ping pong match. Yes, what is your other point? Please be fast.
The office of the chairperson, by reason of his death, resignation, or otherwise, the senior most member shall act as the chairperson of the adjudicating authority until the date on which a new chairperson appointed in accordance with the provisions of this act to fill such vacancy enters amongst this office.
Yes. What else?
So, madam,
So he can also authorize.
He can also.
What is the other?
Madam, this is in respect of the present member acting as a chairperson. But in respect of this, kindly take section 48, authorities under that. Here, enforcement directorate is not mentioned. Here, the designations of the person concerned is mentioned.
Yes.
And the enforcement directorate is under the Ministry of Finance. So, Ministry of Finance. So, therefore, the Union of India is a necessary party herein. May I place a reliance on a judgment on this regard? At
the stage when I'm passing my order, you were relying on a judgment. Is that what prevented you from arguing when the arguments were going on? No, you cannot do this. It will be a travesty, is that? Why should a special privilege be given to you? Give me one reason why a special privilege should be given to you. I'm in the midst of my order, is there?
No, my lord, I did not reply. They raised 3 points, my lord. That
Learned Council also raises. Shut up. Learned Council also relies on subsection 13 of section 6, which provides that in the event of the occurrence of any vacancy in the office of the chairperson by reason of his death, resignation, or otherwise, the senior-most member shall act as the chairperson of the adjudicating authority until the date on which a new chairperson appointed in accordance with the provisions of this act to fill such vacancy, enters upon his office. Full stop. Next para. Learned Council for the Enforcement Directorate, in the midst of the court passing its order, seeks to argue further points on second thought. Full stop. However, such opportunity is not given for the in order to maintain the decorum of the court. Full stop. Be that as it may, Learned Council for the Enforcement Directorate also seeks a day's adjournment to take instructions as to whether the presently functioning member of the adjudicating authority is duly authorized to pass the orders as included herein. Full stop. In order to enable Learned Council to obtain such information, the matter is adjourned till tomorrow when it will be listed at the placed at the top of the list. Full stop. No coercive action shall be taken on the basis of the impugned show cause notice. This is dated November 2, 2023 till December 22, 2023 or until further order, whichever is order. Come with me. Column number 7. উপরে পি লিখে রাখবেন P লিখে রাখবেন। Yes. দেখে রাখছি। তোমাকে ফলো করা লাগবে বলছি ফলো করতে হবে আমাকে বলে দিতে হচ্ছে ইয়েস প্লিজ হোয়াট ইজ দ্য হোয়াট অ্যাবাউট সার্ভিস all the evidence of that service yes what is that
Similar,
I have to know the point first before you go
I took loan from bank, but bank has not insurance for the company, as well I did not get them insurance cover. This is the only one.
I couldn't get your point yes you had a policy
Yes, I took the bank loan, agricultural bank.
yes
But the system bank will disburse the money for part of the insurance company. Bank has not done those, that's why I did not get the insurance.
you are the bank
But the bank will not for the other bank is also part.
yes what is your case
Our case is very good, a very simple point. Due to the server was of the insurance company, we could not upload the details of the farmer. It relates to the farmer insurance, farmer crop insurance. On that point of time, the
policy has lapsed
no details have been uploaded to the insurance company. That is what
insurance company must be a party here
yes.
you have served on the insurance company so what is the present cause of action against the bank that they have not disbursed only this
No, if the other people are the what year they have what are five semester and not the direct state level monitoring committee. This is a secretary taking project. So that can be done
for doing what
for resolve the issue.
what is the issue why should it be referred to some committee and direct them to pay the money why should I refer it to some state level committee and all these things bank says it's a server issue they'll rectify that and they pay the amount
Now all of the chances were because now all of there is no scope to upload the details.
Why?
My because there is specific time. Now there is until my insurance company will further extend the time to upload in the portal.
I direct them to it
Yes.
yes
In my matter, what is substance this insurance was after the farmer to pay the scheme and they has for paying that scheme, he has to sign the scheme document as well as to authorize the bank to debit the premium, a certain portion of premium which the farmer is liable to pay since it is the commercial protector. That's why the state government is not liable to pay the entire premium. A certain portion of premium is required to be paid by the farmer himself, and in the present case, the farmer did not neither sign the scheme document, nor paid nor authorized the bank to debit that particular amount for payment of. For that reason, this.
they did not authorize you did you start the payments did you disburse any of the installments
I have to be bank.
which bank
Not my case.
IDBI.
which items 18 then 10 to 17 করো আর 19 to 27 করো। all the other matters you are in some of the other matters 18 টা বাদ দিয়ে
17.
না না হ্যাঁ দুইটা পর্যন্ত
10 to 17,
কমা
18 to 27.
কমা দাও টেন টু 17 করে দাও কমার জায়গা আছে দেখো তাহলে 10 to 17 থাক পরে বাকিগুলো একেবারে করো
10 to 17.
I'm taking 10 to 17 for the time being. You are in some of the matters. So I'll refer to
Also fine.
Hmm?
Apart from the Bangladesh and other government also fine. I don't know which one.
You are appearing in which of the matters?
Punjab National Bank, I think for 15, 16, 9. 15, 16, 9. First. 10 to 17, I'm for the 15 and 16.
Then let me pass order in 15, 16, 19 first. তাহলে কেটে দাও 15, 16, 19 করে দাও 15, 16, 19 I'm taking up 15, 16, and 19. I'm passing my orders. I'm distributing. Actually, 15, 16, 19. The petitioner's grievance is that the petitioner is an agriculturist. Full stop. Under the concerned scheme, comma, the petitioner held an insurance policy, comma, the premium of which was to be disbursed by the respondent bank by way of a loan. Full stop. Next para. However, comma, the respondent bank stopped disbursing such premiums, comma, for which the insurance policy is at stake. Full stop. Next parallel counsel for the bank contends that due to some technical glitches, comma, the some of the premiums could not be paid by the bank. Full stop. It is also contended that since the payment is delayed, comma, it is no longer possible to pay the installments unless the insurance company extends the time for the payment of the same. Full stop. Next para. Despite service, comma, none appears. Please, item 15, 17 and 19, please file the application of. None appears on behalf of the insurance company despite service, although the bank is represented. Full stop. Next para. It has to be kept in mind that the petitioner is an agriculturist. Full stop. As such, comma, it is not expected that the petitioner would be equipped with the nuances of law and or technical knowledge. Full stop. In any event, comma, since it is not the fault of the petitioner that the insurance premiums were not paid in time by the bank, comma, the insurance company is required to extend the time for putting in such installments. Full stop. Next para. Accordingly, WPA তিনটে নাম্বার দিয়ে না একটাই দাও সেম অর্ডার হবে অন্য 6813 of 2021 is disposed of by directing the respondent stroke insurance company to extend the time for depositing the premiums by the bank. Full stop. Next para. The respondent number 1 bank shall pay the due installments of premium on behalf of the petitioner under the said scheme to the insurance company. Full stop. The arrears shall be paid at one go within a fortnight from date. Full stop. All premiums thereafter shall be paid regularly by the bank, comma, subject to the other formalities being complied with by the petitioner. Full stop. The parties shall act on the server copy of this order without insisting upon prior production of certified copy, nor rest to cause adjacent. Now, এটা সরি নাম্বারটা 15 16 এবার 10 থেকে 17 না 10 থেকে 14 10 to 14
10 to 14.
you are not in any of the matters. What happens if the petitioner does not come? If the insurance company does not come? Neither the bank nor the insurance company. We do not know whether they are on a similar footing. No, your promise won't be because in one of them and at least two of the matters, she's complaining that you have not complied with your formality.
Policy when it is the loan from bank has the duty to give the insurance match.
No, you have to pay a part of the premium.
Yes, sir. From my account, it will automatically go. Bank has the deed to the bank.
You don't have to do anything.
No, no,
Show me the scheme in this. Please come to page 17. This was sent by the bank to you.
yes, sir.
16, 17, they say something is missing. Unable to fill up the data regarding crop insurance.
Or bank. I have nothing to do with it.
Relationship, gender, caste, what are these? Page 17. Oh, help us to solve. You are not appearing. This is UCO Bank. The other matter is also UCO Bank. You appeared, oh, you are for the PNB. Difficulties, we may pass orders, but tomorrow another recalling application will be filed saying that something is. Anyway, it's chapter action এর পড়ে নাও। So they will have the first hearing of the insurance company in the country. In all these matters are taken up together due to identity of causes of action. The petitioners are agriculturists. Under the concerned scheme, the crop insurance policy of the petitioners was to be serviced by way of payment of premium by the respondent number 1 banks. Next para. However, the banks started communicating to the petitioners that they are unable to fill up the data regarding crop insurance for some unknown reason, which apparently is a technical glitch for which the petitioners are not liable in any manner. It is unfortunate that due to problems beyond the control of the petitioners agriculturists, the crop insurance policy is on the verge of being lapsed. Next para. Keeping in view such circumstances and the fact that the petitioners were not in any manner at fault in the insurance policy not being serviced, the bank is required to be directed to rectify the technical glitches and start paying the premiums at the earliest. Next para. Accordingly, WPA chapter number 3 are disposed of by directing the respondent number 1 bank in each of the matters to rectify the technical glitches which might be occurring for payment of the premium regarding the petitioners' crop insurance policies and start disbursing the premiums for such policies at the earliest. The arrears due with regard to the previous installments of premium shall be paid by the respondent number 1 bank in each of the petitions within a fortnight from the date of communication of this order to the said bank. Next para. The subsequent premiums shall be resumed thereafter in due course. Next para. For such purpose, the respondent insurance company in each of the matters shall extend the time limit for paying such premium and upon such payment being made, honor the insurance policy as if there were no lapses on the part of the petitioner and of the bank. The party shall act on the server copy of this order without insisting upon prior production of certified copy in order to cause unnecessary. এবার পরের ভিডিওটা 15 হয়ে গেছে বাদ করছি 16 হয়েছে
হ্যাঁ 19 হয়ে গেছে
তাহলে 18 হবে
18 হবে আর 20 থেকে 27
তাহলে 18 টা আগে আলাদা
সেভেন্টিন
17 এবার আছে 17 বাদ গেল 17 সব একই অর্ডার এগুলো কেউই তো 17 এ ছিল না
না
17 যদি কেউ না থাকে 17 তাহলে সেম অর্ডার 17 টা কল করো 17 কিন্তু 17 দেখো 17 সেম অর্ডার অ্যাজ দ্য প্রিভিয়াস ওয়ান্স শুধু প্লুরাল যা সিঙ্গুলার হবে এবার 18 দেখো 18 what is your difference দাও page number 17 yes careful right Please just take the microphone a bit closer.
State government will bear full premium for all crops except for commercial crops, the cattle and sugarcane, for which the maximum premium should be paid by the farmer will be 4.83%, and the rest if will be owned by the state government as premium. So let's say purely in the present case, the borrower was going to majorly potato, which is a commercial crop. So for payment was required to be paid by the borrower, and for that an authorization was required, which the borrower did not, petitioner hearing did not comply with that formalities, for which the payment was made.
Did you intimate them?
At this juncture, I don't know.
At which juncture will you have documents? The matter is being taken up for hearing.
So I have received.
Yes, what do you say? What is your answer to 11? Clause 11. But that the insurance company will say whether they have paid their part or not. What? How is it linked to your payment?
Yes, farmer authorizes the bank cannot deduct the premium and pay.
But they
Farmer has to pay
State government will bear full premium, right?
in non-commercial.
Oh, these are commercial.
Yes, potato and sugarcane.
Very good. Potato and sugarcane, for which maximum premium to be paid by the farmer will be 4.85, and the rest will be borne by the amount is fixed. The amount of premium is fixed.
Yes, for that.
Even if they don't pay, you have to pay your part.
To get the loan, they have to pay to
the moment I do the
What
work,
author? This does not say about any authorization. And in the absence of any document to show that you have ever asked for them, and you cannot seek any authorization.
the moment I do
Show me any provision that any authorization is required. That may be your policy, but your policy has to be communicated to them. Was even one premium paid in this case?
no. The moment I do
Did they take any? Did they pay any premium?
no,
Not a single premium.
no.
Company was pictures are there uploaded to that page of the matter.
What about your payment? Payment of your portion? What is your answer to this?
When the automatic bank has not disbursed, well, I have no fault at all. The moment I do the loan, bank can immediately disburse the.
No, as per this scheme, they will pay only a percentage of that. You will have to bear 4.85%.
Bank need the moment I do loan, bank has the duty to disburse the amount of the interest component. I have no role at all.
No. This says maximum premium to be paid by the farmer will be 4.85, and the rest will be borne by the state government as premium subsidy. Bank is acting for the state. It will only disburse the premium subsidy, not the entire amount.
So when I do the loan, from my loan account, they disburse the amount to the interest component. This is the system, your system.
Disburse which account? Which amount?
From my loan account, they cut the amount.
Your portion.
It's your portion, Lord. They cut the amount and they will say to the interest component. The farmer has no role.
Now, dispose of the writ petition, they are directed to pay. Learned counsel for the petitioner contends that the petitioner is an agriculturist, and under the concerned scheme, the substantial portion of the premium for the crop insurance of the petitioner is required to be paid by the state through the respondent bank. However, the respondent bank has not made such payments, which has jeopardized the insurance policy itself. Next parallel, counsel for the bank places reliance on clause 11 of the concerned document, which appears at page 17 of the writ petition. Next para. As per clause 11 of the concerned notification dated November 29, 2019, the state government will bear full premium for all crops except for commercial crops, potato and sugarcane within bracket, which is being grown by the present petitioner, bracket closed, for which maximum premium to be paid by the farmer will be 4.85%, and the rest, if any, will be borne by the state government as premium subsidy. Full stop. Next para, it is argued that the petitioner has not given the authorization to the bank for making such disbursals. Full stop. Moreover, comma, the petitioner has failed to pay his portion of the premium. Full stop. Next para. Where perusal of the concerned notification shows that there is no provision therein that as a prerequisite for disbursal by the bank, comma, the bank is to ascertain whether the petitioner has paid his share of the premium. Full stop. Rather, comma, it is contended by the petitioner that as per the scheme, comma, the amount payable by the petitioner is automatically deducted from the loan account of the petitioner at the outset. Full stop. Next para. In any event, comma, I do not find anything in this scheme to stipulate a prerequisite of the petitioner giving any further authorization of the to the bank, and or the petitioner's share being a precondition for the bank disbursing its own share of the premium. Full stop. Thus, comma, the defense of the bank cannot be accepted. Full stop. Accordingly, WPA 13390 of 2021 is disposed of by directing the respondent bank to start making payments of its share of the premium for the for the crop insurance of the petitioner. Full stop. The arrears in such premiums which have already fallen due shall be cleared off by the bank within a fortnight from date. Full stop. Subsequent payments of premiums shall be made by the bank, comma, with regard to the share payable by it, comma, regularly thereafter. Full stop. For such purpose, comma, the respondent stroke insurance company shall extend the time for filing the premium and, comma, as and when paid by the bank, comma, deem the said payments to be valid for the crop insurance to subsist. Full stop. Next para, party shall act on the server copy without insisting upon prior to certified copy, not registered for service. Affidavit of service, সব করে ঢুকে যাবে। The other, how many other matters are there? Nobody is, you are not appearing in any.
Yeah.
20, acha 20 একটা then the same order previous in that was same order as which one? Which item is your first item? 15. 15. আচ্ছা 20 টা বোর্ডে একবার দেখো 20 same as 15
and 23 to 27.
23 to 27 টা একবার দেখো বোর্ডে 23 to 27 দেখো
Except 20, 21 and 22.
23 to 27 also are passing the same order as 15. Very good. 21 and 22 I'll take up after 10 minutes.
21, 22.
Which are the matters where none were appearing? No. Previous matters. Some of the previous matters, none were appearing. তুমি একটু দেখে পড়ো না, none appearing. In a series of matters, none were appearing. Probably 21 to 20, no, 23, 24 or so.
10 to 14.
You don't remember, he's telling you. 10 to 14 করে, thank you very much. 10 to 14 কে appear করেছে other side এ? 10 to 14 এ কোন নাম আছে রেসপন্ডেন্ট? নাম আছে না নেই রেসপন্ডেন্ট? নেই তো, তাহলে 10 to 14 এ যা অর্ডার হচ্ছে সেম অর্ডার। Same order as 10 to 14. Identical because they are not appearing. Yes. Right.
The purchase the property tax.
Yes.
But you can not some other proofs. But after I had purchased, the same certificate was issued on the 30th of June 2020. 30th June 2020.
Right.
Thereafter, I received a demand notice from the Capital Municipal Corporation saying that they have got about 20 lakhs and all outstanding municipal rates and taxes with respect to property for the period 2006 to 2022. Since I purchased from this property, I discharged my burden of paying the Kolkata Municipal Corporation. Ask the bank that you are supposed to reimburse it because this is the period when you have sold the property saying that it is without any income tax. Therefore, this was a period which you are supposed to pay and discharge the statutory burden of the Kolkata Municipal Corporation. You have appropriated my 8.5 crores.
Was there any as-is where-is clause or something?
Yes, I should not that. Page 36.
Yes.
The Lordship will find the sale of the scheduled property last year
Yes.
was made free from all income loss to the secured debtor listed below or deposit of the money demanded by the honest. But accepting this, I don't find any other. Free from income loss.
And have you annexed by any chance the advertisement or anything, e-auction notice, something like that?
Same. No.
Sale deed is also.
But I'm trying to.
Please. I'm also checking out. No, probably it's not. Sale deed must be same as a sale certificate.
The sale deed will
Not help.
The Lordship is right, but the offer, that was the same offer or the invitation. That might be of some consequence.
Yes, because yes.
And so there is an order by the DRP, that is also approved. Because my point is not that the bank made a representation that I am selling it free from income.
Yes.
They took the money, not saying that it is free from income. Therefore, the tweet was based upon their representation.
Yes.
The period for which the corporation has demanded is not when they were not having the secured asset in their custody.
Yes.
And they have already appropriated not on the basis of their representation, it's free from income, and I paid 8.5 crores on it.
Yes, what do you say?
So, I think my election whether there was a publication in the newspaper and there was a call of action where is what is
How it works?
So as there is whatever there is basis, this is the paper publication in Lordship.
Yes. Which portion should I look into?
The option in the
Please mark the portion and hand up to me.
Lordship.
Mr. Mukherjee and Mr. Basu both are appearing. There is nothing in your matter. Yes, you will.
Lordship.
Yes. What was the offer? Let us see.
The property will be sold as is as is what is and whatever there is. This is on such and such. And thereafter at the bottom, the Lordship I have marked. For detailed terms and conditions of sale, please refer to the link provided in South Indian Bank Limited such and such. Detailed terms and conditions were provided in the site of the respondent bank, which I am having, and related to the Lordship. So this is the detailed terms and conditions. So we turn on page 5. 1, 2, 3, 4, and 5. Lordship clause 2.
Clause 2, yes.
Clause 2. The proposed.
Have you got an extra copy for that?
Yes, I have.
Yes.
And I'm also handing over the publication as well.
Oh, thank you.
But may I come back tomorrow?
Yes, go. Just let me see this. Yes.
Clause 2. The proposed tenderer shall read and understand the terms and conditions mentioned in the tender sale notice, which is published by the bank in the website branch at such and such, and satisfy, underline, and satisfy to its area, boundaries, ownership, title, income balances, statutory approvals, measurements, etc.
Let them prepare and come.
And what's this clause 13 and 14 as well?
13 and 14.
Very specific. 13 and 14. Notice the authorized official or the bank will not be held responsible for any charge in income taxes, property tax, or any dues of the government or anybody in respect of the properties under sale. Very specific.
Mr. Mukherjee, you have to take instruction.
But Lord, in spite of that, what my learning shows, Lord, I have not annexed the judgment here. Supporting a bench was affirmed by a division bench, which Lord directed Lord the bank to reimburse Lord to the petitioner of that petition. But of the amount which he had not paid, the Lord to bank on case 64. The operating portion. So Basu had appeared in this.
That's it. There similar clauses were there.
That is the bank sale. As is where is. But I can take your question to the judge.
Another thing, there is an undertaking. I have gone through the terms and conditions and I abide by the same. After that, can he
use your affidavits? You have to put this on record, or you can use a short paper. It cannot be taken up.
Subject to a lawsuit.
Mr. Mukherjee, if you agree to these documents, then we can at least conclude the hearing on this side of the. So you go through these documents, or do you want to? Would you like to conclude today itself?
We need to go through the document.
I think so. Would you like to come back tomorrow, or should I direct affidavits? Whichever way, because these are vital documents. Understood. Very good. Learned senior counsel appearing for the petitioner contends that the petitioner purchased the property from the respondent bank without any encumbrance. Subsequently, however, the petitioner was faced with a claim from the Kolkata Municipal Corporation for property tax for a period prior to the sale. Although under compulsion, the petitioner paid the sale sum to enjoy the property, the petitioner now seeks a refund from the bank. Next para, and counsel for the bank seeks to rely on certain documents. Next para, in order to enable learned counsel for the petitioner to take appropriate instructions on such documents, the matter is adjourned till December 20, 2023, when it will be listed fairly at the top of the updated matters list. Thank you. You can just make it a very short compilation and hand over on the next. I've written all the papers there. Whatever documents you relying on just send. So bring a short compilation of these three documents on the next. Thank you.
29.
40 Yes, what is that? Service?
Issue for supply of security services in the hospital school. The petitioner added upon number 4 considered both tenders were
Take the microphone a bit closer.
post tender means he does not have the professional tax certificate. Subsequently, again another tender has been issued with the same. At that time, his tender has been accepted. Though he does not have a certificate of professional tax, which is mandatory to participate in the tender. Your lordship kindly come
Second tender terms show same as the previous.
kindly come to page 57. Third paragraph 57, your lordship kindly comes to page 76 first.
76 years.
Sixth paragraph with regard to first, second tender.
What is your name?
My name is Newbie Construction. My tender has been rejected.
Yes.
This tender has been accepted. That is at clause 2, tender construction.
You have been rejected on the same ground.
No, not on the same ground. Because
Then what is your locus standi?
Professional registration.
But you don't have a locus standi then.
The tender has been accepted.
You have been rejected in your own right. You have been rejected.
If they have accepted now, take their own norms.
Suppose even if I set aside that acceptance, you don't gain. So you don't have any locus standi.
Fresh tender will
You have to stand. I mean, you have to stand benefited by the setting aside.
a fresh tender will be issued where I can participate.
But
Because
you
if
have
they
been
cancel
rejected on some other ground, firm name mismatch and whatever.
But if they cancel their tenders on the ground that it is not
Devnath Construction is the only one who is qualifying it. Oh, then you say that the entire tender goes.
They will try to come to page 7.
Yes.
That is the rejection of the argument.
Right.
Well, clause 3.
Professional tax.
Paragraph 3. Professional tax registration certificate in each channel deposited in the last 6 months from the scheduled date of the tender opening was submitted as per the. Now, I will kindly come to page 46, termination, page 57. Clause 18.3.
Page 57.
Page 57.
Yes. Clause 18.
Clause 18.3.
See.
If any document required to be submitted for e-tender by the bidder in its technical proposal is not submitted or is found to be deficient in any manner at any stage after opening of the bid, that bid may be summarily rejected.
Show me the professional that tax certificate provision.
But can come to page
17. 72.
That is the documents which is required to be submitted with the bid.
Right.
But column 5.
What is the substantial clause which says that if this is not submitted, then it goes?
Any document, but that is a.
So 18.33 you are connecting this. Very good. So this is a place. Link names. Yes, please.
Submissions are not on video.
Yes.
As your lordship has found in several such cases, we have put some floating seed. Lordship see the incongruities in the document. We notice 24 November 2022 annexation to at page 17.
Yes.
This is the notice in respect to the second call. The heading.
Right. This is regarding the previous tender.
But
because let me see the rejection of the previous tender, that is of the date is 31st of August.
74.
No, this is after that.
August 2022.
This is after that.
So second call
Yes.
went through, and your lordship will find the next page, which was again shown to your lordship at page 76, is not the list of successful bidders in respect to the second.
Oh.
But please see page 76. Third call. So, it's very possible that the third call tender, the professional tax must have been paid. I tell you not why. Because that's the only issue. The lordship please sees the petition, the reading at page 5. Page 5 of the petition, second last paragraph. Fifth place, since there is no registration of professional tax in the name of respondent number 4. As such, there is no name of respondent number 4 in the concerned tax agreement. But after making payment of professional tax in the name of wrongful party or the proprietor, the respondent number 4 was selected as successful. So evidently, the defect, if any, in the earlier calls must have been cured, and ultimately the third call must have been successful. And the third call which is being included today, but please see the date. The 6th of January 2023, we are in December 2023. But the 8th of December 2076.
No, repetition was filed in February.
Perhaps no steps have been taken to have it heard.
What steps could be taken? Due to us, it is not being.
No, steps are being
Cactus curing.
And you can get option. No, cactus curing is not apply unless you show that you mention the matter again and again.
I know what I do to the mention. I can take judicial notice of that also. Anyway, so you say that it was cured. Apparently, it was cured.
That is that is one aspect of the matter. But please have a look at the second call terms which have been annexed. Your lordship was shown 18.3.
Yes.
But please take a look at 21.2 at page 58.
Yes.
During evaluation, the committee may summon bidders and seek clarification for information or additional documents or original hard copies of documents submitted online. If these are not used within specified time, they will be liable for rejection. So it's possible clarifications were because otherwise such a long period of time, and in fact, this is for 1 year with an option for renewal of further years. The kindly comes to the first page of the notice, page 17. You'll also find that the third line is for a period of 1 year, like to be extended for 3 years. So 1 year is virtually extension. 1 year is virtually passed.
Wait. Yes. What is that?
Giving extension how the farm is done.
This is based on conjecture. How do we know that these conditions were not fulfilled?
Because they did not have professional tax.
That is your averment.
They paid on this ground on the earlier occasion.
Maybe in the earlier occasion, but in the second occasion they may have obtained. How do we know? You are taking a chance.
The professional tax registration is required. If any employee gives the salary for the then the farm has to deposit this professional tax.
Well,
And
in
what
page
the-
5, we have stated that they have produced something. So it was on the authorities to consider whether that is
They
sufficient.
have produced the professional tax certificate of this particular person,
Who is the sole proprietor?
but the farm has to be registered because if the farm, there are two professional taxes they have to deposit. One is the owner of the farm who is earning, and the second is the certificate of the farm under the Professional Registration Act, because otherwise the farm could not deposit the professional tax before the authority,
Since it was in the name of the firm.
since it was in the name of the farm. And they did not have this professional tax registration. But in spite of that, he has been selected by the CRT.
No interference.
But can appreciate.
Appreciated.
But can appreciate one thing.
Fully appreciated.
If they could not fulfill the rules, then the law of estoppel is not applicable. I have here to challenge the date.
No question of estoppel.
I have participated in
They
the
have challenged in February. So no estoppel.
discussion. Now, if they did not have this professional tax registration, they could not participate even. But in spite of that, his tender has been selected.
This tender was for what purpose?
Tender is for supply of security service in the various hospitals in the district of Lodi. So let them file a report whether this professional tax registration is there or not. Everything will be clear.
Not every petition can be.
But only one point that they did not have this professional tax registration. If they file a report that they have professional tax registration, I have no case. But if they could not file any professional tax registration, then he become unsuccessful. His data has been accepted wrongly.
Learned counsel for the learned counsel for the petitioner contends that the petitioner participated in a tender for providing security personnel. Push up next para. The first such tender was cancelled, since none of the participants fulfilled necessary criteria. Push up next para. The respondent number 4, one Messrs. Devnath Construction, also failed, inter alia on the ground that it failed to produce the professional tax certificate. Full stop. Next para. Subsequently, it is argued, a fresh tender was floated in which both the petitioner and the respondent number 4 also participated along with others. Full stop. Whereas the petitioner's bid was rejected on other grounds, the bid of the respondent number 4 was accepted on the premise that the bid was as per norms. Learned counsel for the petitioner contends that the respondent number 4 did not have any professional tax certificate in the name of the said firm, even at the juncture of the subsequent tender, and as such, the selection was improper and divorced the conditions of the tender document. Next para. Learned counsel for the petitioner places reliance on clause 18.3 of the tender document, which indicates that if any document required to be submitted for e-tender by the bidder in his technical proposal is not submitted or is found to be deficient in any manner at any stage after opening of bid, the bid may be summarily rejected. Next para. By placing reliance on the chart of the documents required to be produced, which is also a part of the tender, it is argued that the said checklist included professional tax registration any challan deposited in last 6 months from scheduled date of e-tender opening. Next para. Insofar as locus standi is concerned, on the query of food, and counsel for the petitioner argues that if the petitioner succeeds, the entire tender process is required to be cancelled, as the respondent number 4 was the only successful bidder. Next para. Learned senior counsel appealing for the respondent authorities places reliance on clause 21.2 of the tender document, which provides that during evaluation, the committee may summon bidders and seek clarification information or additional documents or original hard copies of documents submitted online. Next para. Also placing reliance on the averment of the petitioner in the writ petition at page 5 of the same, it is pointed out that even as per the petitioner, since there is no registration of professional tax in the name of respondent number 4, as such, there is no name of respondent number 4 in the concerned tax enrollment, but after making payment of professional tax in the name of Ratan Kumar Devnath, the respondent number 4 was selected as successful bidder in respect of the said NIT. Next para. It is also pointed out that the impugned tender was on the third call. Learned counsel also places reliance on the second call annexed at page 17 and submits that as per the same, the tender is only for 1 year, subject to renewal at the end of each completed year. Next para. Learned counsel for the petitioner contends that the respondents are about to renew the contract in favor of the respondent number 4. Next para. It is seen from the impugned rejection of the petitioner and acceptance of the respondent number 4 dated January 6, 2023, that the petitioner, comma, in any event, comma, was turned down on at the technical stage, comma, having failed to comply with provisions other than the one now complained of. Full stop. Hence, comma, the present challenge at the behest of the petitioner is extremely limited. Full stop. The petitioner has to show that the bid of the successful tenderer, that is respondent number 4, was so violative of the provisions of the tender document that no reasonable man would accept the same. Full stop. Next para. It is, comma, in any event, comma, well settled that the discretion lies ultimately with the employer, stroke tender issuing authorities, to ascertain the interpretation of the clauses of the tender and as to the weight, WEIGH, to be attached to each of the clauses there. Pushed up. In the present case, comma, even if it is accepted for argument's sake that the tender issuing authorities had accepted the professional tax certificate in the name of the sole proprietor of the respondent number 4 firm, comma, it is not for the writ court to substitute its own prudence in place of that of the tender issuing authorities. Full stop. Next para. In the event the petitioner was rejected on similar ground, comma, the petitioner would have an arguable case on such count. Full stop. However, comma, it not being so, comma, the petitioner cannot take the point that the tender issuing authorities erroneously interpreted the tender clauses. Full stop. Next para. In any event, comma, the writ petition has been taken out as a chance proceeding, comma, on the conjecture that the respondent number 4 did not comply with the tender conditions relating to furnishing professional tax certificate. Full stop. There is nothing on record to clinch beyond reasonable doubt that the respondent number 4 did not have any professional tax certificate at the relevant point of time, or that the respondent number 4 had not satisfied the tender issuing authorities in terms of clause 21.2 upon giving a subsequent clarification after submitting the bid. Full stop. Next para. Thus, comma, the present challenge has to enter the arena of conjecture and surmise in order to succeed. Full stop. However, comma, the well-settled legal principle is that the call of the tender issuing authority is final insofar as the implication of a particular tender clause is concerned. Full stop. In any event, comma, the tender has since obtained fruition, comma, since the work order issued to the respondent number 4 has almost reached its terminus. Full stop. Next para. In such view of the matter, comma, the writ petition does not call for interference under Article 26 of the Constitution of India. Full stop. Accordingly, WPA 3879 of 2023 is dismissed on contest without any orders to cost. Yes. Right.
A very short second minutes. This is the money that after the value. The last option after the condition value. When you take your worship order, the entire mallet thing mallet boils down to 2 points. When you take your worship order, paragraph 13 of your worship order is
Yes.
that for the mallet immediately. Then mallet, the bank also has to explain as to whether it has a proper committee as contemplated the above referred handbook in place leads to decision included here. Moreover, bank is also required internally to explain as to when communicated to the IPA for putting the people's name in the question list, as well as explain when the order was not communicated to the petitioners, to the petitioner. But after that, they relied upon certain documents in their everyday position. I relied upon the same document. They admittedly say that there was no committee as per the handbook, but that is not required. It is there. And the order was never completed. Not even appended with this opposition. Their communication has been happened. The order has not been married.
Were you given any hearing before blacklisting?
Yes. But the committee will be a hearing. But it was not a proper committee as I shown from the handbook of the
Did you take that point before the committee at the hearing? Can you raise that point subsequently?
There's a question of jurisdiction. And both of them, they say the Indian Bank Association REIT is not maintainable against the Indian Bank Association and the Indian Bank Association is the registered society, the consortium of banks, private and public sector banks. From there, the evidently in opposition, it is clear that Indian Bank Association is active.
There must be a lead bank.
No, there must be a consortium of banks.
So what is your answer to that?
They are the annexes. It's clear the RBI has been directed to act to the Indian Bank Association, disseminate this kind of knowledge of the opportunities. And RBI has said this is Indian Bank Association is acted in the public interest. That is clear. And I will show you from their annexure. Kindly take their annexure that page 11.
Yes. Yes.
But kindly take from paragraph 3. That is from the circular of March 16, 2009. The review of fraud is undertaken by us has revealed that in many cases, inputs provided by the third parties were misleading or distorted. Often the third parties which are apparently issued document statements were found to have actively colluded with borrowers and facilitated the credit sanction. There is no case made out here. In case of housing loans, we have observed that the builders in active connivance with the borrowers have entered into settlements with paid amounts and multiple documents and loans sanctioned or delivered. So, this is for the purpose of this circular has been issued. Then, kindly take I am not take much time. Kindly take paragraph 4.
Yes.
Similarly, valuers, advocates, and chartered accountants have also been found to be facilitated participation of frauds by providing certifying fake documents, certifying incorrect information, legal opinion on financial statements, statement of accounts of borrowers' properties taken as security by the banks. So, this circular is for the third parties, for the M panel, this is chartered accountants, professional.
You are included.
I am the
Yes.
Kindly take paragraph 5. It is therefore necessary that the banks build up internal database of third parties in a systematic manner and resort to mutual exchange of those data on an ongoing basis. Banks may thereafter report to Indian Bank Association the detail of such third parties, including professionals involved in fraud, before reporting the IBA. Banks have to satisfy themselves the involvement of third parties concerned and also provide them with an opportunity of being part. That has been given. Kindly take the next. The second paragraph again. Issue was deliberated at the managing committee meeting. This is a managing committee set up by all the banks on the direction of the Reserve Bank of India. This is response number 3 here. Deliberated at the managing committee meeting when it was felt that dissemination of details of unscrupulous professionals amongst member banks through the forum of IBA, this Indian Bank Association, would benefit the industry at large. As per the committee's decision, a working group, core group was formed to examine in detail the procedures and prepare draft guidelines. That draft guidelines is the one of the handbook and procedure. Those are all of 2011. And this is the one of the handbook. I already handed over the handbooks to.
Yes.
Then kindly take the page 30. I'll place the handbook letter. Kindly take the This the points I taken up for the purpose of they say against the Indian Bank Association, we will not counter. So I say the Indian Bank Association is acted for the public interest. The public will be administered.
Wait.
So
Let us come straight to the handbook.
handbook. But kindly take this circular.
Yes.
One
Very
page
well,
of
yes.
this circular, page 14. Page 14.
Yes.
Pudam has been proposed at page 14, that cross file.
Right.
Pudam to evaluate the role of the third party entity in a fraud and lawsuit. I am a third party entity. It is proposed that an independent and empowered forum to be set up to evaluate the role of third party in fraud cases. So, independent is there. Kindly take them the handbooks prepared by the same bank. I don't already tag.
Yes. Yes.
So, there that the independent valuer has to be a part of the committee. But I will say that independent valuer has to be the member of the committee, like independence of the committee. Other members can be of the bank. I'm not saying so. For the independence of the committee, a valuer, professional valuer from an expert valuer, or from the valuers association, valuer should be there.
Yes.
So, it is admitted fact there is an independent member in the committee.
No independent member.
No independent.
Where is that admitted? Where is that admitted?
They say that is not required.
Where is that?
Kindly take page 3 of their manual.
Yes.
Page 5.
5, yes. 5.
Page 5
Yes.
In terms of the aforesaid RBI circular of March 16, 2009, that I may not pay information. The respondent bank has set up an independent and empowered forum to evaluate the role of TP in fraud cases by their policy in third-party entities policy. According to the policy, the forum is to consist of personnel for 5 departments being legal department, inspection, business department, compliance department, credit information, credit monitoring department. So there was no independent valuer was there. All these departments of the banks from the one professional from
which policy are they referring to?
That I placed on March 16, 2009.
Very yes.
Where Reserve Bank of India said there must be a guideline. I showed the guideline of 2011. The guideline, they say there should be one independent valuer.
Do they refer to this handbook in their opposition specifically? They say they are relying on a policy annexure D. Let us see annexure D once. It specifically rely on annexure D. 20.
Is their policy.
Yes.
I need to take my page.
22 is the forum.
25 also their document. I rely upon their document of page 25, that is annexure D. I can show the members of the set. The members reflected in the March 16, 2009, and the handbook members are also set. I can show from that in compared to this circular and the handbook, because the members of the banks and some of the names are also set.
Have they annexed that committee report?
Committee report of against me.
Yes, or the hearing minutes.
No order has been annexed. Only the communication has been annexed. No signature of the committee member was there. Kindly take the communication. But the order has not been annexed.
Need not, but they are relying on paragraph F, page 5. They said that this is the committee, this is the composition of that committee, and they rely on D.
And the order has been amended. I don't know whether the order has been passed by the committee members. That is not specifically matter they have said matter.
Opinion formation may not need a detailed order.
Only a
When admittedly hearing has been given,
yes, here
they have to form an opinion.
form an opinion. One opinion must be an independent opinion.
Definitely.
And there is no independent value over there. There's no that is why Malar Forum said there must be an independent value over should be. I say Malar that can be a bank's opinion. That can be a bank's opinion. But for that opinion, Malar my on Article 21 must have taken away by all the banks because of Malar the upload in the question list.
So your primary ground of challenge now becomes the composition of the committee.
Number one, and IPA, this is not the Malar, the IPA is Malar the handbook. IPA should have Malar, but consider that Malar there was no Malar independent value in the form. Because Malar that Malar my name Malar reflected in the Malar the caution list. That taken over by Article 21. So all the panels of all the banks have been Malar taken over because of the caution list. This is the dispute industry between this South Indian Bank and me. South Indian Bank can form an opinion.
So your entire dispute is regarding this composition of the committee primarily?
Yes.
Composition of the committee.
Composition of the committee. The order has to be communicated. That your lordship not I can
the order of the committee.
First against me. Before Malar, it was been Malar reached me. Malar, my name has been Malar uploaded in the motion.
Of the IBA.
Of the IBA. And Malar, all the banks has been Malar suspended. Till date, Malar, I don't know Malar.
After giving you a hearing, I mean, that may not vitiate their order. Post facto non-communication may not vitiate them. Because you don't have any further right of hearing. That is the reason.
Yes.
Even if it was communicated to you?
I don't know, there's a looking of mind. I don't know. Yes, sir.
So boils down to ultimately that composition of the
committee and no independent Malar the valuer in the
obvious. Let us come. Yes.
But for the fact that IPA, it is merely an association of all banks, which only facilitates that the banks are allied in the various policies implementation and dealing with the unions and various. It does not have a statutory changes. That knows, as a matter of fact, all the banks are basically governed by the Reserve Bank of India guidelines, and all the licenses are also granted by the Reserve Bank. So today, for all practical purposes, whatever I am to do has to be under the guideline of RBI. Whether or not that guideline is in the same lines as what the IBA is speaking of. That is my first argument. Also, I would have really appreciated had my learned friend shown my lot by placing my opposition and being fair enough to me to demonstrate as to whether the policy that I am talking of, so that page 20 my law is discussing, whether that policy is what emanates out of the guideline, which I have next year also in my RTI. Before I go to that case, I will first move on to refresh the facts of the matter. Show cause, two show causes were issued to Commissioner. After the show cause, a hearing was granted. He participated in the hearing virtually. On the first day, his stand was I was not given a personal hearing, though he was provided a virtual hearing. Thereafter, he was communicating of the order, not a written communication, but oral communication that will emanate from the petition. When we kindly take it main matter 17 of the petition. The petitioner was a valuer with two branches of money, Park Street branch and Balaji branch. When we kindly have a look at page 9, value 7 of the petition.
Yes.
That your petitioner submits it as a settled principle of law that every public functionary in whatsoever sphere must be guided by legislative procedure prescribed under the procedure. It is in fact that as 1, 2, 3 are failed to adhere to their own prescribed procedure, and your petitioner was not afforded any opportunity of hearing to clarify his stand with prescribed committee. The decision-making process again begins with the matter. Till date, no order has been communicated to your petitioner, but it was learned from the Park Street branch that your petitioner has been this should be, and your petitioner's name has been sent to IBA. It has been, so he is aware of the order, and that is the reason why the cause of action of the writ was, I had on the presentation, had mentioned that it is, I cannot go beyond the facts. As a matter of fact, I have not communicated the order in writing to him, but not that he's not available. Secondly, Milind, and till date it's not been communicated. Milind had also put a pertinent question to me as to what took you 15 days to not communicate. But yes, it is with army had communicated on legal team, the legal team had thought and they had sent it. In that misunderstanding, it was left unsaid. And Miller, once the writ was filed, we did not want to thereafter make any communication to him just to better whatever wrong was done.
Yes.
This was the stand on non-communication of a written order. Now, Miller, what stands is that IBA is the body which was, let me see, this is not a blacklist, it's a caution list. But all the banks, they have to be at least aware of those valuers or advocates or whosoever who have been not being diligent. Delinquent, these people are delinquent. Now, there has to be a forum whereby I can caution you that if you are dealing with these people, please do it at your own discretion. It's merely a caution list published in the guidelines. Now we will take the guidelines. And I will also show as to whether the guidelines and the handbook is referring to, are they in the same format as what the RBI has spoken. Now we will see with this 19, this is circular number 1331 at page 12 of the page.
Yes.
This circular is 1331 dated 27th August 2009. But this is a circular which says it has to be, will I just take the first paragraph first?
Yes.
In terms of the RBI circular dated 18th March 2009, banks have been advised to report to IBA details of third parties, including professionals involving fraud. Before reporting to IBA, banks are required to satisfy themselves about the involvement of third party concern and also provide them with an opportunity to concern. Banks have been advised to follow formal procedure and suitably record the formal process is followed. Though banks have been advised to report such incidents with respect to self-regulatory organization of these professionals, banking system as a whole needs to be cautious about these third parties. Hence, RBI has requested IBA to prepare caution list of such third parties for circulation amongst banks. So it is at the request of RBI that the IBA puts forward a caution list. Now, what is the caution? How do we determine the delinquent? Now, let us see at the bottom of the same page in July 2009, a procedure was set forward. Now, let us see this mentions about the circular 16th March 2009. But I will only rely on certain paragraph 2 minutes at page 13.
This is an RBI circular.
Yes,
Very good. Yes.
This clause 2, definition of third party entities. But I have tried my best to read this with the handbook. I do not find even one clause in the handbook which is about this.
So this is more of an advisory of the IBA,
The IBA
which does not have statutory force.
says that this is what we are advising, and it does not mention. But nowhere apart from this handbook mentions of an independent person. I'm coming to think of the fact that when runs a case, that the independent person from the fraternity has to be. This is what he is saying.
That's a good point, actually.
But then that's not what the RBI also mentions of. And the various policies that
Let us see the RBI thing.
No, it's not.
No, let us see the RBI. Yes.
We kind of take clause 2, definition of third party entities. Third party entities are individuals or group of individuals, whether incorporated or not, used by a bank or its customers, agents for their product, service, expertise, and knowledge. These entities sell products.
Valuers is there, the last. Yes.
Identification of TP and creation of database is also what I will rely
Yes,
on.
yes.
Then when we come to paragraph 5, the clause 5. For forum to evaluate the role of a third party entity in a fraud or a loss. It is proposed that the independent empowered forum be set up to evaluate the composition of the forum. The forum would consist of 3 to 5 members of sufficient seniority from various control functions. One person among the members will play the role of coordinator. This would typically be the group which reports frauds to RBI. The group which has uses the services of TPD shall also be a part of the forum to decide on the particular case. While the chief vigilance officer of the bank would be a member of the forum shall not have any of the persons who invested in the case. The composition has to be this. So now if I go back to my composition, it's
But it has to be read in conjunction with the first sentence, independent. The first sentence, forum to evaluate the role, it is proposed that an independent. What is the independence in your office? Yes.
Now, bank has various departments. It might not be, that's what the general means. One department dealing with one particular type of issues. The others who are there for forming part of the forum might not have a twist the same person with it. So now that would be independent. Otherwise, the composition, while they're making emphatically when they're mentioning composition of forum to have 5 senior members, they would have nothing to
Please,
say.
Shah, please clarify this phrase also to me. 8A, the forum should consist of 3 to 5 members. The various control functions. What is this? Internally within the bank.
Yes.
Control functions with different departments or different.
Various departments.
Very.
Bank has various facilities. Now let us see functions of the forum. The functions of the forum, even processes of the evaluation committee, everything is identical with my policy. When I take my policy vis-a-vis this page.
So how do you say that who will be an independent person, any employee of the bank, how can he or she be independent? I mean, ultimately it's the bank which decides as a whole body. I mean, the bank decides that this person has committed fraud on the bank. So which is the department which has to be excluded for the sake of independence? I mean,
that's why
which is the concerned department?
That's why they say that the forum, which is, we will see the last line, while the chief vigilance officer of the bank could be a member of the forum shall not have any of the persons investigated the case. So therefore, the independence, the person who has investigated the case is not the judge also.
Yes.
That's the reason why it has been categorically mentioned that the person who is investigating the case is not the person who is the chief vigilance officer.
You have disclosed the composition also.
Also, this is the RBI guideline which is found. Now, let's also see the process mentioned here with row and clause 6.
Yes.
Clause 6 of processes of various divisions it has. At the end of the day, the process only mentions you have to give a show cause, hearing, and
process modality has been complied. They are not on.
Now, the next clause 7, receipt of costly list from IPA. Each bank will receive costly list from IPA containing details of including costly list as reported by member banks. On receipt of the list, the bank should check the names in the bank's database, add the names of costly list database if not existing already. If there are TG in the list sent by IPA, the bank is already using, then the group would notify the group which is using the service. As I mentioned, if you are, it's only a caution list. If you are still agreeing to deal with a delinquent person, you're doing it at your behest. Then we will see.
No, this is a stigma. It's a stigma. In the professional sphere, this is more than a stigma. It's akin to a blacklist.
Yes, akin to a blacklist. For which a disciplinary proceeding has been carried out after determination if the person is held to be delinquent, but whether or not the person is saying calling himself to be a saint, once he is arrived at the public sector is exposed to these. One bank, second bank, third bank, we are coming across cases of this every day. So now, if one bank is not exposed to these people, when we are only trying to bring it more, it is going to have a very, very, very vulnerable and catastrophic effect. So this is part of that. If I try to manage this handbook with this procedure or the guideline section, I find not even a single rule akin to it. This is a handbook on policies, standards, and procedures for real estate valuation by banks and HFIs in India. This is only, this came out in February 2011. I tried to read each and every part of it. Let us see the contents with the policy first. Let me take the policy, which is at page 22 on page 23. I do not see anything similar to the guideline which has been set by RBI. Nothing with it. Then we'll see page with page, this particular page number 1.4, removing, having the guidelines is, there is a page number, page 28, I'm sorry, page 28.
Yes.
Removal, show cause, hearing, appropriate action, re-evaluation. Thereafter, I tried to do everything.
No, clause
Date of
3,
effect.
clause 3.4 is there.
Yes.
Yes.
The date of effect,
Yes.
page 32 minute. This document should come into effect from such date as shall be notified by the IIT. All banks and housing finance institutions take all necessary steps, including order approval and capacity building measures, and prepare themselves to implement this document. Now let us see. When I come to the 3.4, let me see what does it set out to. 3.4 is under part C, procedures. Procedures for call for application, procedure for selection, procedure for annual performance review, procedure for conflict resolution. Now we can see what is conflict resolution. There are bound to be a variety of conflicts when hundreds of valuers are impaneled by various banks and financial institutions across the country. In every bank, HFI, there shall be a bank valuation conflict resolution committee for addressing all conflicts and arriving at amicable solution. The composition of the committee shall be decided by the respective banks, HFI, and shall include representatives of national value associations. In case of any misconduct by any value, the bank or housing committee still have a prerogative to recommend removal of the value. The step involved in processes showing the show cause, hearing, deliberation. In case the committee opines on charges, errors the values are serious. The banker may be removed from the panel and depending on the seriousness of the case, he may be impaneled once again after that. But just one thing struck me right now. We talk about independence. If amongst the valuers, one valuer representation is made. He is for his brethren. If not the bank entirely, the various functionaries of the banks are not called to be independent. How can I call the valuer a representative of the entire brethren as an independent?
No, at least there will be a balance between the two. The interest of both the parties will be represented. I mean, without any, then they can at least portray they will also have an assessment of their brother or sister whoever. I mean, and they can project the viewpoint of the valuer also, which is not present at.
Which blood?
It is entirely the bank. You are the bank, different departments of the bank. Only the investigating officers are not there.
Coming to think of it, that any disciplinary proceedings in any organization is also the same in nature.
That's true.
So I do not.
So this is more than that. You are putting him on a list which says the other banks will also not take him. Obviously, no bank, every bank will take him at their own risk.
Yes.
So you are doing that. You are going to that extent. So the consequence is higher.
It's also after paying the caution list.
Yes.
Many banks are still carrying on valuation done by those delinquent valuers. For me, he might be delinquent, but for others, he might not be delinquent. Until unless they come to a call of that sort.
So it boils down to the binding effect of this vis-a-vis this.
Yes. Now that I show, this is a conflict resolution issue that I show. Now let us see my policy. My policy is identical to this policy of the bank. RBI, sorry.
Page
18.
Yes.
This is by the ID.
Yes.
You see in the background issuing a framework for revitalizing distressed assets, which provides guidelines for distressed assets resolutions of the NPA. RBI requested TBA to consider creating a portal central registry for correctly facilitating details for delinquent chart accountants, advocates, valuers, and who has committed serious irregularities in the course of rendering professional services to the bank. So then they are talking about the various deliberations that they've had. The managing committee of deliberation decided the IBM and right to banks to make this and we need to cross the third bank. follow the constitutional guidelines issued by IB for reporting of third-party entities involved in fraud and give parties a fair opportunity to explain their position for reporting their names to IBA for principal is caution is not. The committee was of the view that no separate reporting needs to be provided since IBA is already being with the terms of treaty, namely CS and member banks are requested to strictly follow the constitutional guidelines issued by IBA. White circular number so and so 1339 dated 27th August 2009. Which year is this? 27th August 2009. We'll see that at page 20.
No, that is 27th August.
Yes.
Yes, 27, right.
Before reporting the name of the chart. Whatever I have to follow is this guideline and identical with each and every line is identical.
So this does not say anything about these guidelines.
Independent, yes, that's not wrong. Now, and also, like, this is 2009, this handbook was in February
No, but
2011.
this is the draft guidelines contemplated in in the August 27 guideline circular.
What
The
is
draft,
this?
the second paragraph of August 27, page 12. Second paragraph, last sentence is the draft guidelines vetted by the.
What, July 2009.
Oh, achha.
Also, Millett, this came out in February 2011 and also says, Millett,
No, this is no, not that. Oh, achha, right.
this handbook came out in February
These
2011.
draft guidelines were adopted by this meeting. So
Yes.
guidelines were previous.
Also, we will see, it is this one, the procedure which is on page 12 of my opposition.
Yes.
Procedural guidelines for reporting names of third parties involved in frauds to IBA for inclusion in the cost.
Yes, obviously. These were considered already, and this is of 20.
And on policy standards and procedures for real estate valuation by banks and HFI. But there are separate guidelines also.
We'll continue after the recess.
So I have.
You have finished.
And
You have finished your arguments. Mr. Shah will continue. If you want to say anything further, just instruct him. I want to conclude the hearing of this. Need not go to another.
I finished it. Only because mine probably the way I have addressed would not.
Then it will continue tomorrow. Then let us come back tomorrow.
Take part only 2 paragraphs.
Yes, first let us finish. Hard in part for further hearing tomorrow.
I'm sorry, but I.
No, it's all right.
This fix.
No, it's all right.
Tomorrow,
We'll continue after the recess.
I will.
Renew your prayer when I take up the one. Not like this. Your other side is there. Who is your other side?
There is a practice.
When I call the matter, then renew your prayer. WBACDCL, Pushap, Learned Counsel for the WBACDCL hands over written instructions and indicates that the WBACDCL shall positively give such connection to the petitioner subject to compliance of formalities by the petitioner by December 31, 2023. Pushap, it is submitted that for giving such connection, a transformer is required to be installed, which is the reason for the delay. Pushap, keeping on record the written instructions, WPA 21762 of 2023 is disposed of by directing the WBACDCL to give a new electricity connection to the petitioner for operating his submersible pump, subject to compliance of all formalities in that regard by the petitioner, positively by December 31, 2023. No address to cause others. Every service to be kept. Yes. Mr. Haldi also have to deal with the materiality point. Let me just check up the release. Yes, yes, I'm this. You really? Yes. What is the matter, Mr. Haldi? Please take the microphone a bit closer. Yes.
The respondent back,
I don't understand.
I have 80
A lease has been granted. You have granted a lease to the bank. So what happened then?
the bank has already started their business. Therefore, in the midst of the tenures of they have kept their bank from a limited without paying the outstanding fees.
This is a civil dispute, Mr. Halda. Outstanding dues, you have to prove by way of evidence. What are your dues? As per the, let me see the agreement, lease agreement. Miss Halda, you'll have to go to the city court. I'll give you that. Yes. Yes. Offer.
And there was a situation of 15 years. But they're running the business, banking business.
Right.
In the midst of the stipulation, they have kept their bank money without giving any outstanding fees. We have stated my
Was there any moratorium? Was there any period before which they cannot leave? What is that?
Yes, continue. For least year 15 years.
Take your seat. Yes.
Least year 15 years.
Acha, very good.
From the year of
Is there any prior determination clause? Is there any prior termination clause?
No. Yes, stated that it nothing lead to delinquent and their bank without giving a offering.
Read court cannot injunct them from shifting. I mean, there is no agreement not to shift. How can the read court grant any relief at all? If you are agreed by your monetary claims, you have to make a claim for that. File a suit. How can the read court decide the monetary claim? They have paid nothing according to you.
Yeah, the student bank have to maintain the stipulation like 15 years. Before 15 years, they are delinquency by
No, Mr. Halder, it's a purely civil dispute. Learned counsel for the bank at the outset takes an objection as to maintainability since the dispute is civil in nature. First of learned counsel for the petitioner contends that there was an agreement between the bank, respondent bank, and the petitioner. Full stop. Pursuant to the same comma, the petitioner granted a 15-year lease to the bank. Full stop. However, comma, much prior to the expiry of the same comma, the bank is seeking to shift from the petitioner's property, leaving substantial dues on account of rental payments. Full stop. Next para. Learned counsel for the bank controverts the said contentions. Full stop. It is also submitted that there was no formal lease executed between the parties despite repeated requests by the bank. Full stop. Next para. Although the petitioner has annexed at page 14 of the petition an offer by the bank, which purportedly is in the nature of an acceptance of the lease, comma, the claims now made by the petitioner are in the nature of injunction and monetary claim, comma, to get relief on which count the petitioner is required to satisfy the court by adduction of elaborate evidence. Full stop. Next para. As such, comma, the dispute raised in the present petition is purely the subject matter of a civil dispute and cannot be adjudicated within the limited trappings of evidence by the writ court. Full stop. Hence, WPA 21896 of 2023 is disposed of by granting liberty to the petitioner to approach the competent civil court with the reliefs as sought in the present writ petition. Full stop. This court, comma, it is made clear, comma, has not entered into the merits of the allegations and counter allegations between the parties, and it will be open to the civil court, comma, if approached, comma, to decide such issues in accordance with law independently. Since no affidavits have been invited, comma, it is deemed that none of the allegations made in the writ petition are admitted by the respondents. No address to cause. Thanks. Yes.
Any vote?
Yes. You supplied stale food.
Yes.
Stale food to the hospital.
No, not stale.
Yes. What happened this time?
No.
What have you done? Oh, this is steel authority. Sir. In this matter?
Was mentioned under not proceed with the entire tender, but not to give the affidavit of opposition has already filed and it is reply is and it is also served upon the respondent within time.
Opposition you are filing now.
It's already been filed.
So I'll take up after the vacation.
There is an interim order passed on 17th October 2020.
Not to do what? Oh, tender.
When you take 31st is the last minute, thereafter I have to do something. Otherwise, the entire hospital.
After very. Yes. Yes, RBI.
That was my submission.
That was your submission. Right.
And the existing contract. I want to file the additional application for the additional money.
The existing contract is completely on 34th.
Have you got a copy of the writ petition?
We have participated in the tender process and also we have filed the application for the extra.
I'll add you on oral prayer. Give her a copy of the writ petition. No, they are affected directly. If he wins, the tender goes. If he wins, the tender goes. That means.
So far as interim is 31st is last day. Otherwise, I would not have given lordship trouble. I have not even minded because of the things sort of.
Very well, hear you. I'm adding you on oral prayer. Allowed. Today itself. Yes, absolutely. Yes, sir.
Yes. The writ petitioner is challenging the policy of procurement.
Wait a minute. What is your name, please? Atulya Sinha. Your name.
Yes.
একটা order record করে নিতে on the Mr. Pal, how are you affected?
As per my information, my is I don't understand technical. Only is been open
on the oral prayer of Ms. Atulya Sinha and Mr. Sharup Pal, who have instructions to appear for bidders in the tender process which has been challenged before this court, their respective clients are included as parties to the petition, pushed up necessary details regarding the names and addresses of their clients be furnished by said learned counsel to the learned advocate on record for the petitioner during the course of the day, in order to enable the learned advocate on record for the petitioner to amend the cause title by including the said parties. The writ petition is taken up for hearing in view of the extreme urgency involved. Please give your names, your clients' names and addresses right now. And Mr. Sinara ensured that even if you lose the matter, those names are incorporated.
Yes, sure.
Yes. What is it? Take your seat. Yes. No time.
This is a tender matter for procuring the
Overcome the locus standing point first. You did not participate in the tender one, and
yes. First point is this will not, as the particular tender doesn't disclose anything, and they have taken 2 points. One point is this, that I cannot achieve the particular financial eligibility condition. So far, I have annexed this particular petition. My first argument to this, Miller, the particular financial eligibility which they have suggested in their tender, Miller, that is vague, and actually, Miller, this is an exaggeration of the eligibility, Miller. I have also compared the particular tender with the other tender document, Miller. I have considered that tender document as the standard tender document. My first case is that the tender does not reveal any schedule. First, manpower schedule is not given, from which a particular man should have been quoted.
The tender is for?
The tender is for cook diet.
Cook diet, very well, yes.
Cook diet for Steel Authority of India.
Manpower strength, required manpower strength has not been given. What else has?
But that is in vague. First of all, the bed has not been, the number of bed has not been disclosed properly. It has been disclosed that the entire hospital is containing 600 beds with 30% occupancy. That means 200 beds are operated. So, and there are certain, I am referring here one thing.
When was the tender floated, Mr. Sinara?
It was floated on 2nd September 2023.
2nd September 2023.
Yes.
It is for what period? What is that tender?
Actually, this is for 2 years, and but initially it is to be given for yearly contract, and then thereafter 1 year is for
September 2023.
September 2023. That is the NIT date, 2nd September 2023. It is happening from the page 7.
Why are you saying it is expiring on 31st December?
Contract is
Oh, you have to give this. Good. Please sit. Right. Yes, Mr. Sinha, please.
Yes. First of all, this is a contract tender for the for supply of the cook diet, and thereafter,
page 55 is the notice inviting tender.
Here, page 17 is the NIT. Page 17 of the petition is the NIT. Where it will appear that this is the 2nd September 2023, and details of the scope of job. Details of the scope of job is at page 21. Scope of work to provide
Yes.
Details of the scope of work, indicating all aspects and facilities of the execution of the job, to provide entire kitchen and cafeteria services by developing fully include kitchen, providing raw materials, serving all the meals, breakfast, lunch, dinner, snacks, beverage for the patient, employees of the steel plant, and the doctor, faculty, students, staffs, etc., and visitors, patient, and their relatives. Now we are the location, and these are not very relevant. And then next page, we are providing of trained manpower. Service provider shall engage qualified and experienced workforce of head cooks, assistant cooks, helpers, steward, and carers. The service provider shall issue identity card. So the number of cooks is a service provider shall provide experienced workforce of head cooks, assistant cooks, 3 sorts of cooks in plural number. Number has not been mentioned. helpers, stewards and bearers. My first submission is that, I have one identical tender document for this purpose.
So you are relying on page 66.
Yes.
Details have been given there, here it has not been given.
Yes, 60 beds to 100 bed, 5 stars. So it is
Very well.
more than 200 beds.
Here nothing of that sort is there.
Nothing of that sort.
What is the other ground of challenge?
Otherwise, why I'm referring to this, my lord, there are the staffs which can be counted from here. There are 3 sorts of staffs referred here. And if it is a plural number, we are 3, not 3. Head cook, assistant cook, helper, steward, and bearer. 6 sorts, 6 types. And if this is, then we know what, and those are all in plural number. So we have to show that this for the 200-bed hospital, how many cooks, how many stewards, how many other staffs and bearers are required to be appointed. Because that is their demand, they are to show, and I am to fit with my budget. Being when I will offer
Mr. Sinarai, you have to procure raw material, cook the diet, and serve the diet. For that, how many people are necessary for you? That's your headache.
No.
Why do you say that? Suppose I can do the work with 10 people. You can do the work with 20 people. I'll code for 10, you'll code for 20. I'll have to. My job is under the tender is to provide food, to procure raw materials, cook it, provide it to the patients and all these people.
Yes.
So it's my headache.
Yes, that is true. But
so why should they put in a number? I mean, this number of cooks.
Actually, that is that has been
done in previous cases, not done here. That does not resheet the tender.
No, I'm sure.
In fact, too many cooks may spoil the broth. So therefore, they have not mentioned rightly. What else? What other ground?
Other ground is that then they have provided. Actually, the manpower and all I am challenging, and
mainly manpower.
Only manpower, and there is a practical situation is that they were deducting entire thing from the entire they have made a committee for taking considering whether I am paying the statutory dues and all. Yes,
the number of beds of the hospital has been indicated anywhere here.
Yes, 35.
Where is that?
Slightly wrong, this page 45. Terms and condition, the 600 bed, the occupancy ratio is 30%. That means it's a 200 bed hospital. Production of distribution diet, regular diet.
So what else do you require, sir? This is sufficient indication. If you have past experience, you can do it.
This and for this 200 bed hospital,
you have got your second hearing fees. That cost me.
I'm relying on judgment.
Cite it. Yes. It's a pleasure to look into judgment.
Page 69, para 69.
Give the citation.
That is
1994.
660, page 651. Tata Cellular versus Economy.
Which paragraph, Mr. Sinha? Sorry, I missed.
16.
16. Yes.
Attendant is an offer. It is sometimes which invites that is communicated notify acceptance not listed that following are the series of a direct tender. It must be conditional, must be made at the proper place, must confirm the terms of obligation.
Which criteria is not satisfied in your case? All the criteria are satisfied.
That must confirm the terms of obligation. That terms of obligation is not specific here. As because that is their hospital, they have to show their manpower. They have to set their manpower. That this
Where does the obligation come from? Must conform to the terms of obligation.
terms of obligation means when I shall employ the manpower without their
Your obligation.
Yes.
I mean, the terms have to be clarified.
Yes. So we not
No, this says must conform to the terms of obligation.
Yes.
Conform means some obligation is already there. You have to conform to that.
They have offered something for supply of the food diet, and there is no schedule of the manpower.
All right.
Manpower schedule is essential that is given in every tender except this tender.
Very well.
Second, third, there must be reasonable opportunity of inspection that they have given. So,
yes.
8 is tender must be made to these are all first of all is must conform to the terms of obligation. So if I have tendered the bill, then I have to be given an opportunity to know how much manpower is required, because they have said it's a 600 beds, but 200 occupancy is the average of the occupancy. But for the 600 beds, how many manpower is required? That is their obligation to do.
What other judgment?
Other judgment is Governor Daram Shakti, that has not been followed here, but my argument on this point is this, the Steel Authority is also an authority under Article 12,
yes,
and they cannot act arbitrarily. I'm relying paragraph 12 of the chapter. Reference to 1979, Supreme Court cases 490. Not arbitrary. That is Article 14. 480.
How is Article 14 violated? Everybody is given the same opportunity.
Yes.
So how is Article 14 violated then?
See, there is when the offer has been given to it's an offer. When the offer has been made, they have not given the schedule of the manpower, which is the essential schedule. And if I have said that I will apply the 10 persons, 3 persons, 4 persons, that is not. There should be a standard minimum manpower schedule is required to be adhered with the particular 10, which has not been given. That's all.
I've heard all of it. Possible. The heard learned counsel for the parties. First up, the challenge to the present tender process is primarily on the ground that the exact manpower required and the number of beds regarding which cooked food diet is to be supplied by the petitioner was not enumerated in the impugned tender document, thereby vitiating it according to the petitioner. Next para. Learned counsel for the petitioner places reliance on other similar tenders floated by different authorities, also annexed to the writ petition, in support of the proposition that in all those tenders, the exact number of beds and the corresponding staff required to be deployed were specifically enumerated. Next para. It is argued that in order for a bidder to participate in the tender properly, such numbers are essential to be known prior to participation. Having not been disclosed, the said omission vitiates the tender as a whole. Next para. Learned counsel places reliance on 2 judgments of the Supreme Court, respectively Tata Cellular versus Union of India, reported at 1994, 6 SCC 651, and please take your seat. And Ramana Dayaram Shetty versus International Airport Authority of India and others, reported at 1979, 3 SCC 489. Next panel. A perusal of the said judgments indicate that those do not come directly to the aid of the petitioner in the present instance. Full in Tata Cellular Supra, it was stipulated by the Supreme Court that certain requisites are to be found in a valid tender. Full For example, it must be unconditional, must be made at the proper place, etc. Learned counsel for the petitioner places particular reliance on one of the yardsticks stipulated by the Supreme Court, being that a valid tender must conform to the terms of obligation. Next para. However, in the present case, there is no obligation in the first place for the tender issuing authorities to conform to in order to render the tender valid. The question of conformation to the terms of the tender document itself only comes later, after a work order is issued. Next para. Thus, the said judgment is not apt for the present consideration. In Ramana Dayaram Shetty Supra, the Supreme Court stressed on the compliance of Article 14 of the Constitution of India. In the said judgment, the court considered whether the government should be or not be free as an individual in selecting the recipients for its largest. Next para. In the present case, however, there is no allegation, nor has the petitioner established that the tendering authorities have tailor-made the terms of the contract to suit any particular bidder or a class of bidders. No malafidez and or arbitrariness has also been made out by the petitioner, since the terms of the tender are equally applicable to all bidders and, in fact, several bidders have already participated therein. Next paragraph. A perusal of the scope of work as reflected from the tender document shows that the same is to provide entire kitchen and cafeteria services by developing fully equipped kitchen, producing raw material, cooking and serving of all meals for patients, employees, etc. are also a part of the work contemplated. In the second, now in one of the clauses of the tender document, it has been stipulated that service provider will engage qualified and experienced workforce of head cooks, cooks, assistant cooks, helpers, stewards and bearers. Next para. In fact, in the terms and conditions of the tender, the number of beds in M&HS, Durgapur Steel Plant has been enumerated to be 600 beds with occupancy ratio around 30% approximately. The general proportion of distribution of diet between regular diet, enteral feeds, ENTERAL, feeds stroke liquid diet, therapeutic diet, all other diets has also been given specifically therein. Next para. Thus, the total number of beds and the approximate occupancy rate, as well as the necessary specifics for the work contemplated, are sufficiently given in the tender. As to the number of qualified head cooks, etc. to be employed for achieving the work contemplated in the tender, it is for the bidder to ascertain the same. Next para. Hence, the tender issuing authorities have not committed any such grave error so as to vitiate the tender process itself. Next para. In any event, it is well settled that it is within the domain of the employer to ascertain the stress to be given to particular clauses of the tender and as to what exactly is sought by the said authorities. Full stop. The interference of courts of law in such arena is extremely limited. Full stop. In the present case, comma, the petitioner having failed to make out any exceptional circumstance to so interfere, comma, the writ petition cannot succeed. Full stop. Accordingly, WPA 22585 of 2023 is dismissed on contest without, however, any orders to cost. Can such and such is accordingly disposed of as well. Sorry, Mr. Senator. Please do that. Yes. Please ensure that that is done.
Yes.
Becoming disheartened, leaving the court, forgetting to do that, won't. Yes. Next. Thank you. Yes, Mr. Vandit. So,
Is the challenge
challenge to IBC. Why should I take it up? Give me one reason why should I take it up before the next.
apart from
Yes, sir.
no instruction has gone.
So again,
No, when we are just communication between the officer,
Mr. Chakraborty, I'll take it up after this. Come back after the news. Since a challenge has been thrown to the virus of the Insolvency and Bankruptcy Court, and the matter requires elaborate hearing, comma, in view of no such urgency be found, comma, let the matter be adjourned.
so sorry, but it's a limited challenge to the provisions of our section 8.
Till after the vacation, stop. যেখানে চ্যালেঞ্জ কথাটা বলেছি না, একটা লিমিটেড কথা, লিমিটেড।
But the urgency may not be there, but of course, we have prayers for each order so as to not
Not into what?
because one of the section 8 company one is before one of the NCT one of them one of
Virus challenge,
pressing not
virus challenge, IBC virus challenge,
no
whatever response.
applicability of those provisions were for section 8 or the judgment of the arbitrated company holding a particular provision of this
Accordingly, let the matter be listed at the top on 2nd January, Mr.
Second one is after you second. We can get it to a third.
What has happened, Mr. Was something wrong?
Second input you want your officer's experience.
January 3, 2024. এটা করে দিয়ে দিন। Yes, Mr.
My appearance, whenever I appear in
What is being
my name is recorded simply on my name, neither my designation nor as signature.
Please ask your learned junior whoever is putting in the slip to put that, because that is not being whatever is given, we are following. I don't look into that. Actually, my officers follow whatever slip is given. It's happening to High Court. Utterly. No, probably, I mean, I shouldn't comment here. Something in between has happened to. Third, stop. Yes, please. 36 to 38. In all the matters.
Just for the educational law, kindly see page 28. Your lordship's order. That is eligibility of service, but that order.
So application has to be considered.
Yeah.
Yes, I'll do that. I'll not give the specific page numbers because that will. No, I'll not give the page number. There are 6 matters. Oh, 3 matters only.
Page number is annexed. Then
the annexure number is same in all the matters.
No, this matter.
This matter is
25.
page 25. Also, very good.
Exactly.
Then
matter number 6.
the limited prayer of the petitioner is that the petitioner's application for educational loan be considered by the respondent number 6, the branch manager, Union of India. Full stop. Next para, heard learned counsel for the parties. Full stop. In view of the innocuous prayer made, affidavits are not being directed, and it is deemed that none of the allegations made in the petition are admitted by the respondents. Full stop. WPA 23291 of 2023 is disposed of by directing respondent number 6 to dispose of the application for educational loan made by the petitioner as annexed to the present petition as expeditiously as possible, positively within a fortnight from date. Full stop. No address to cause urgency. প্রথমে এফিডেভিট সরি ফাইল টু দিবি next two matters same one exactly oh respondent number 8 আচ্ছা next matter টা 37 এর respondent number 8 হয়ে যাবে 6 and 38
respondent number
7 7 6 8 7 thank you. You are in all the matters.
37 and 30.
Acha, please ask your learned junior to just write the item numbers. In which you are
I'm in the
so when you write the item numbers in which you have not written the item number.
I have.
36 হবে yes
You handed up.
39.
30. You're for the electricity board.
No,
State test for you're then who are you appearing for?
Person to minor mother, blood grievance are free.
Regressed. What was the grievance?
in 2017's order, we sought for certified copy in 2023 June and have been given. Thankfully, Miller, the record has not been placed.
Yes.
Lordships on the last occasion saying that whether the records is
Yes,
there or
exactly.
not.
That is the main concept.
But
Learned counsel for the petitioner submits that during pendency of the petition, the concerned certified copy has been handed over to the petitioner, thereby ending the cause of action of the present petition. Accordingly, in view of the above submission, WPA 23878 of 2023 is disposed of as infructuous without any order.
end of this document, this is the report of the district judge.
The report filed on behalf of the learned district judge Murshidabad today be kept on. কি দেখাচ্ছ অরিত্র? Get what? You have got the certified copy that is sufficient. And you will get a certified copy of this order. Okay.
At least High Court's intervention copy has been handed.
Their intervention. Yes. Yes, please. What is the matter? Kolkata. Yes. Yes. Right. Good service. Very yes. Matter is also equally good or bad?
No, it's equally good.
Equally good. What is the matter?
Because the only issue for application to the lordship is petition to that.
Yes.
Because the CSC authorities are entitled to give the electricity connection for private respondent number 6 from by installing electric meter in an adjacent separate neighboring house that is mine under the guard of compliance of your lordship's order dated 14th of November 2020.
The electricity has been given over your property.
No, it is supposed to be given. Now I raise a check and it has a check and pass. May I take your lordship's 2 days of your lordship time to pay the tax?
Yes.
But the issue is that, my lord, my father owned a building with land. Now it has got this partition between me and my brother.
Yes.
My brother is no more. The portion is made now by the plot. Now, my portion is clear. Now, the portion of my father, there is a standalone unauthorized construction 9.45 square meters. Now, private response number 6 is continuing an obviously business on the standalone structure, unauthorized structure under 3 trade lists. Be that as may be, now there is a long-standing private dispute between the landlord and the tenant. The landlord says that they are the occupied.
This private respondent is the tenant, the alleged tenant of your brother,
of my brother.
brother's heirs.
But there is a private, long private dispute. They say, landlord says that there is not a tenant is occupied.
Very good.
They say that they have a lease.
Occupation is undisputed.
That's okay. That they have taken proceedings before the KMC, the under construction. The signs and the buildings are being removed, and it's on the verge of demolition. They have private respondent number 6 has approached the report. They have modernization. That's it. In that juncture, one of the private respondent number 6 approached your lordship's court for a grant to visit. You also must need to pass the grant to with the director skills authority to grant necessity within a fortnight, but subject to non-payment of any other special. Now, the minor question is that order your lordship passed on 15th of November 2020. Now, my premises in that, but this your lordship appreciates that my brother's premises is only a standalone structure.
You are a party to that petition.
Yes, I was the party.
You are represented.
Yes. No, I was equal. What I have done.
He says yes, you say no.
Not in the final order. There was dictative order there. I will represent.
Yes. Anyway, it was fair enough. Fair enough on your part.
Yes. Now the
issue was nothing.
Yes. Now, my lord, may I first indicate your lordship the separation of the premises that will make your lordship priority keys. If your lordship comes to page number 30 and 31.
Yes.
Now your lordship page number 30, your lordship will find my name. That this is the name of my daughter of my late father. Premises name is city only, and if your premises number, there should be active number, and the number is 1A, Longnathpur Road, West Bharu. This is one premises. Now, if you also comes to page out 31 for once.
Your premises is different.
My premises is different. So it has got bigger it was 1, it was
now 1 and 1.
Now 1 and 1.
Very good.
Now this unauthorized construction is in 1A. They are seeking connections by installing an electric meter in my premises of 1. Now, in spite of that action of CSC will vitiate my right to honor of A, is also practical difficult. I have given under my instructions the place of my meter in my premises and the distance of the standalone structure where it have to be given is a distance of about 15 feet. Now, if there is only one way that the electric connection can be given to the standalone structure, from this way, right, by making overhead bands, then that overhead will continue with my premises also. And that has a risk of life and livelihood of the residents living there. I am only.
Your building is how many stories?
It's I have no problem with it, whether if your lordship will get to giving the connection to the one is up to theirs, not regarding mine. I only want it.
Not regarding?
I got no hamper in my property. They give my lord their lordship because these lordships are
from their premises they have to be given.
Yes, that's it, my lord. They can't have them my. That's it. Only that.
Let us see. Yes.
The kindly see page
54.
Yes. That is your
yes.
Can you see the second paragraph?
Yes.
Kindly come over and see the last paragraph and page.
Cannot get any special equity.
Problem from your lordship. The difficulty that pursuant to this order, we have tried many times, but we could not.
Sir, Mukherjee, what is the difficulty in giving it from their premises?
At the time of the final hearing, my lord was not there. It's quite concerned.
No, now I'm asking you.
But now
give it from their premises.
But 1 year has passed. But if you have given from there, then again you see what is the condition. But in the meantime, there are certain appeals which has been filed, which we
appeals by whom and against what?
There are certain orders which has come up. No, there is a case.
So that is regarding the demolition. That is that has no nexus with.
Then we have to go and inspect.
So that. Yes, you are for the private respondent.
Yes.
Yeah.
And for the state.
You are for the state.
They file the repetition method on the basis of the presentation of that method, the repetition method in paragraph 6, where they have stated we are doing illegal occupation. And I have the
Legality of occupation is immaterial.
its deed was there, but
Legality is immaterial. You have entered into legality.
was the report method and page 154
Very good. The conspectus of the present petition is limited. First up, the petitioner alleges that the private respondent is in occupation of a standalone and independent building situated at premises number 1, 1 capital A, Rangonathpur colony, whereas the adjacent property, that is 1, Rangonathpur colony, belongs to the present petitioner. First up, next para, it is contended that the two premises are distinct and different after having been partitioned between the petitioner and his brother since deceased. First up, next para, the private respondent is an occupant of the adjacent premises at 1 capital A, Rangonathpur colony. First of it is contended that although there is dispute regarding the legality of such occupation and a demolition order at the behest of the corporation is pending, comma, it is not in dispute that the private respondent is actually in occupation of the adjacent premises. However, comma, in the garb of complying with an order dated November 14, 2022 of this court directing the CAC Limited to give electricity connection to the private respondent, comma, the CAC Limited is seeking to give such connection from the petitioner's property over the petitioner's property from the source meter, which is situated about 14 feet away from the premises of the private respondent. For giving such connection, comma, it is alleged that overhead power has to be drawn over the petitioner's property, which would hamper the rights of the present petitioner, comma, who has a two-storied building on his property. It is further argued that the petitioner does not have any objection if the order is duly complied with by giving connection from the property of the private respondent. Next para, learned counsel appearing for the private respondent controverts the allegation that the position of the private respondent is unlawful. Be that as it may, comma, the issue boils down to whether the electricity connection can be given in compliance of the order dated November 14, 2022 from the property of the private respondent and not over the property of the present petitioner. Next para, in order to ascertain the feasibility of giving such connection from the property of the private respondent, comma, the CAC Limited shall hold an inspection upon prior notice to both the petitioner as well as the private respondent within a fortnight from date, upon prior notice to both the petitioner and the private respondent, and file a report on the next returnable date with advance copies of the report both to the petitioner and the private respondent. The matter shall be listed clearly at the top of the list on January 3, 2024, 3rd January. Report filed by the state today we kept on. Yes.
41.
Appearing? What is the matter? Please file the affidavit services. What is the matter? Please use the microphone, ma'am. Marginal farmer, yes. Not being given. Yes, why are you not given?
This is running condition loss in 2013, but loss in 2018, somehow banned. And thereafter, 2019 January, we paid as per quotation 10,000 rupees. That's finally happened. Paid 11.
Yes, then what happened?
Then lordship, thereafter lordship paper and visit and also application, hardware application, they are not much more educated. But they did not go there. That's it. Then page 21, what is short lordship came up before.
This would be Dware Vidyut. This would be Dware Vidyut. Not for anyway.
Lordship, Dware after that time, he made after application before this Dware short.
Why Dware short? Because you have already paid for the replacement of the
Already told them.
but not at all lordship, it's all the meter and also lordship, it is the tradition of this West Bengal electricity lordship ad hoc payment made lordship. That is the problem of this lordship. And huge amount dues, they are not.
What is your present grievance? They are not replacing the meter.
Lordship, after filing this application, just 1 month, not only 1 month, 20 days before they install the meter. But outside they have stated so.
So now your grievance is settled?
Not only grievance is lordship, one grievance is settled.
What is the other?
Lordship, the other is lordship. You in rainy season, that time no lordship submersible is required. That time they also lordship bill sent to them and ad hoc payment, whichever is lordship 2018 10,000, 12,000 there. Now lordship 25,000 and each and every time they are paying when they are selling paddy or another crop, that time they paid the 10,000, they are 30. If you not pay then because then we will can't be in this way lordship.
But never
I appreciate, but if you have a grievance regarding the billing, this court is not required.
Apply the authority council.
You have done everything. Why have you come to this court?
But not they did not bother us every time. Now they are.
There cannot be a blanket order. They won't do it. What can the court do?
Lordship's court, lordships,
Even lordship's court can.
They are saying lordship, if it's not one, then lordship will take initiative. What will it take initiative? Lordship.
I don't understand your problem. I mean, they're overbilling you. You have already lodged a complaint regarding.
Lordship, 3 months, 2 months after, they are sending bill 5,000, 10,000, 12,000.
They have to send bills because that is their business. WBSCTC does not do it for free.
That's why they are demanding. In 2018, they paid amount. They applied, proper applied meter, finally install the meter. But they did not say that. That's why it is their business. I appreciate, but also in this way business, another business also pay. Or farmers, if they are not alive, then how can lordship they doing their business lordship? Now they are in lordships, tremendous situation. They are not able to pay lordship. My submission is just
When did you apply before the grievance redressal officer? You said you have made an application regarding the billing dispute. Where is that?
Lordship, page 20. Page 20, lordship.
Yes, there is an it has been registered. Your complaint has been registered. This is the registration. This is the complaint regarding defective meter or billing.
Oh, both that. That's it. কিন্তু এতদিন হয়ে গেল মিটার পরিবর্তন করা হয়নি যেমন খুশি estimate or
Please approach the grievance redressal officer for the billing dispute. I'll give you that liberty.
That's it. Another thing, they are always threatening cut off the meter. You were not.
That is a law.
That's it. But
They'll obviously cut off meters within cut.
Connection is there, man.
Right. That's sufficiently simple. For what?
For inspection the ground, what amount we are consume this electricity. My production is not 20,000 and they are telling the bill loss is 25,000 above. Then they are not in a position.
The grievance in the writ petition is twofold. So first, it is alleged that despite the petitioner having written on several occasions, the faulty electricity meter was not being changed, However, it is contended that during pendency of the writ petition, recently the faulty meter has been replaced. Full stop. Next para. The second limb of the grievance is that the WBSCDCL is allegedly overbilling the petitioner, charging exorbitant amounts for periods when there was no cultivation of any crop by the petitioner, as such, there is no scope for uh, expenditure of electricity for operating the submersible pump. Full stop. Next para. Occasionally, the WBSCDCL has also been threatening of disconnection if the petitioner failed to pay such amount. Full stop. Next para. Learned counsel for the WBSCDCL reiterates that the defective meter has been replaced. Most of that apart, the fact that the electricity meter has not yet been disconnected itself shows that the WBSCDCL has not been coercing the petitioner. However, the allegations made on overbilling are refuted. Next para. Since the law provides for a particular forum to decide billing disputes, that is the concerned grievance redressal forum, it would only be prudent to relegate the matter to the said authority instead of the writ court usurping such jurisdiction on facts. Accordingly, WPA 2822 of 2023 by granting the petitioner liberty to approach the concerned grievance redressal forum with the billing dispute as sought to be raised herein. If so approached by the petitioner within a week from date, the grievance redressal officer shall decide the same as expeditiously as possible in accordance with law and dispose of such grievance within January 31, 2024. Next para. Within a week, within a fortnight. Till the said dispute is redressed by the grievance redressal forum, the WBSCDCL shall not disconnect the electricity supply of the petitioner on the ground of non-payment of the amount regarding which the dispute is raised, subject to the petitioner going on paying current electricity charges regularly in terms of the bill raised by the WBSCDCL. However, in the event the petitioner does not refer such complaint before the concerned grievance redressal officer within a fortnight from date, the above order shall automatically stand vacated and it will be open to the WPSCDCL to take appropriate action in terms of law for non-payment by the petitioner of the bills raised by the WPSCDCL. No rest to person. No. Grievance redressal officer. It will be a copy paste of this. Your learned friend will guide you. He may also write the complaint.
Next to matter,
Same. Same counsel also. But
next matter, one meter installed.
Matter or meter? Next matter, 1 meter has been installed. So no grievance now. Same order. Correct.
Next 1 meter installed.
Next matter is item 42. Item 42 also same order.
Same, not 43, 1 meter.
42.
42
Same order. 42 same order. 43 tak. 43. 43 what is that?
Same
But-
matter, but 1 meter installed, 1 meter is not installed.
Meter, now meter.
1 meter.
What is this 1 meter is this?
my told him that for all installed.
What?
1 meter installed.
How many meters are there?
Connection is there.
Where have you ever that? In your reflection? Yes, Ms. Ghosh, where is the
ID number was in page 19.
Customer ID number, 2 customer IDs.
Customer ID docket number doesn't page 19.
Which has been replaced? Which has been replaced and which has not been replaced out of these 2 customer IDs?
Dot six. I think the one.
You think means?
Dot six.
Come prepared. Come prepared, come back tomorrow, prepared which meter has been connected. On the after vacation. No,
Fourth January.
4th January, come back 4th January. They've already got 2 orders, so 2:1.
Not my business, dot six. This is.
No, very well. These are agriculturists. I'll make it not.
That is my here. 4th January.
Why 4th January? Because these are
Dot six.
cultivators. Come back.
That's the one meter.
Come back. Come back. In order to enable the counsel for the petitioner to take appropriate instructions at a 43, the matter is adjourned for the day and shall retain its position in the list. Please come back. These are cultivators. Let us be kind to them. Yes. Next one. Oh, sorry. What is this?
See for intelligence. That here, repetition. Urgency is in connection with the application of the MSc comes. I have also also recent going also. But here, the challenge is one from ground, which is different. One, the authority concern in Delhi, the district magistrate is.
Come back after the vacation. Not no.
The only urgency is.
No. So many matters cannot be. So many matters are already there.
Anyway, before the vacation.
Don't beseech. Don't beseech. Come back after. I'll in due course come back after the vacation.
After conciliation, they have initiated the reference. The claimant has been asked to file the statement of claim, and this court only by hearing section 11 had allowed my section 11 where reference is continued.
You mention all these in your objection. Take a point of jurisdiction and you know what to do.
Kindly permits the person first.
No, this will take the intent. Definitely not before.
I will not take more than 10 minutes. By the law,
I will take more than. I will take more than that to understand the matter.
Stop me, my lord.
No.
My lord, they are proceeding.
I'll stop you and you stop.
Yes, I will.
No.
But I will stop.
No.
I will only show.
There are much more serious matters. People are.
But if I don't have a case, my lord, I will not, my lord, bother your lordship for more than 10 minutes.
No.
Kindly permits me Thursday or Friday, any day, my lord.
No, Mr. Not
Reopening, my lord. I have to, my lord, come.
I'll repeat here. Mention after the opening.
Business, we can see, my lord, how, my lord, burdensome this court is, my lord. Kindly.
I can also see. There's a difficulty. No, sir. Come on. These matters can wait. I mean, there is urgency. Yes, he mentioned. Oriya said mentioning. Oh, yes.
Last Monday, when I mentioned Lordship said he wait for a week, then he mentioned. Now, item number 6 not now, it was a passport.
Item number 6.
Yes.
Let me take up the matter. Yes. Follow. Enough words. You don't have ever really enough words.
No, not enough words. This will be slightly important. But item number 20 of today's list, in the unlikely that it's not called today, we taken up sometime tomorrow and just in 1 minute I'll explain what the problem is. My property, building, I have a lessee, he's running a hospital without any fire license compliance. But I'll be gutted if something happens. There's a fire license memo which is issued on them saying you don't
No, this is not so much of an urgency.
No, it's just that something happens and
No.
the law is my liability.
Refused. Yes.
Side.
Yes, Mr. Rathod. Yeah. You are getting cut off on the last occasion. I'm not literally. Let us see whether the blessing extends to the order.
I can say undisputed submission. Well, where I am satisfied.
Yes. What is the matter, please?
But Christianity, they are given member of the bar.
After.
The member of the bar, and what happened, your lordship actually wife minor abandoned, and thereafter mother and wife remarried. Even after abandoning minor, she has filed many technical cases for which her parents and retired, and this suffered that is just
What role Mr. Banerjee has in all this?
but he has retired.
Mr. Banerjee had a role in all your matrimonial disputes.
No, I only this case, your lordship.
Yes. So then what happened, Mr. Dhatt?
So, madam, what happened, your lordship, actually thereafter I came to know that she has been married. So multiple litigations going on in between them.
What is your present?
The present minor, that was she got remarried. So thereafter I came to know of that her remarried, and I have taken a certified copy of that marriage certificate.
She got remarried after getting divorced from
From the divorce marriage. Yes, that she did.
very.
Then what I did, then what I took a certified copy. So my case is that by the Article 261 of the Constitution of India, which is and case by the quoted case of the Constitution, your Lord, and Section 79 of the Indian Evidence Act. This page 3, paragraph 2, I am stating Article 261. Page 3, I am reading that.
Yes.
Full faith and credit shall be given throughout the territory of India to public acts, records, and judicial proceedings of the Union and of every state. This is Article 261. So therefore, Lordship, it comes Section 79 of the Indian Evidence Act, which says the court shall presume to be genuine every document but pertaining to be a certified or a certified copy or other document which may not declare to be admissible as evidence. So your Lordship, actually, I produced their certified copy before the landed court. This is the certified copy of the marriage.
Certificate copy of what? Her marriage certificate.
Marriage certificate. The marriage certificate.
Yes. Then you produced it before where? Which authority?
And you go to the landed court. There are maintenance cases and other cases are going on. This maintenance case.
Then what happened? What is your cause of action?
So cause of action is that on the basis of that, actually a party, very influential party will come through. Family members are also online. So what happened? One of the criminal cases were initiated against me that I have produced a forged this certified copy. So in these criminal proceedings, I am keeping on going on proving that certified copy is true, which is a 1 minute part for them to go and apply for certified copy. It can be proved at any time.
Yes.
So here my prayer is that my Lord, what is discrimination? This in regard to the certified copy produced by the actually married sister of the Muslim marriage.
The discrimination between whom? What is the discrimination? They have an allegation that the certified copy is forged. They have to prove that it is forged. That will be proved in the investigation. If they fail to prove, they fail.
But they have not. I have proved in a criminal case.
You are not proving, Mr. Dutt. A presumption is raised. A presumption is rebuttable. This is a presumption. Evidence Act is not conclusive. It's a presumption which is raised. Presumption of correctness, which can very well be rebutted by somebody on the allegation of fraud. If it is found to be fraudulent, then you go. Otherwise, you remain. What is the harm in that? Where is the discrepancy, discrimination? No, what is the final relief? Why should the petition not be dismissed?
Just break for only one affidavit from that. This is a false or this is
No, Reach court cannot pass the direction. That is the subject of investigation. No. Oh, what sort of litigation are you? Yes. If they have lodged a complaint that it's a fraudulent document or a forged document, that will be decided. A criminal case is going on. Let it reach its culmination. Let it reach its culmination. What can the Reach court do? Their report is not sacrosanct event. They may file a report saying it is fraudulent or non-fraudulent, but that still remains the subject matter of investigation. That report will only be a piece of evidence, Mr. Dutt, in that investigation or the criminal trial. Who are they? They are the authority, the registering authority. Marriage register. Even if the marriage register gives a document and says it is authentic, even then that will be only a piece of evidence in the criminal trial, where an allegation of forgery is there. They may be a party to it also, to the forgery. Who knows? I mean, we are not alleging anybody against anybody, but they may be a party. What is the scope? This writ petition is frivolous, Mr. Frivolous. I should impose cost on you. You pay 1 rupee to Mr. Banerjee for unnecessarily embroiling him in this.
That guided me.
Oh,
they guided me not to do. They guided me not to. But this thing.
Then pay 50 paise. 50 paise is no longer available. Even 1 rupee is not available. The petitioner alleges that false allegations of production of a forged remarriage certificate of his wife has been made against him. Next para, it is alleged that the criminal proceeding in connection with such false allegation is pending since long Full stop. The petitioner seeks the marriage registration authorities to produce a report to indicate as to whether the certificate is fraudulent or not. Full stop. Next para. According to the petitioner, comma, such production of a report will clinch the issue in favor of the petitioner. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that the petitioner alleges that although he produced a valid certificate showing the remarriage of the petitioner's wife during subsistence of his marriage, comma, the same was sought to be disbelieved due to the wife's efforts to malign the petitioner by making allegations of forgery against the petitioner. Full. Although the petitioner says that the document is not forged and seeks the marriage registration authorities to produce a report in that regard, comma, such report, comma, at the best would be a piece of evidence in the criminal trial which is going on the basis of the allegation of forgery leveled against the petitioner vis-a-vis the concerned remarriage certificate. Full stop. Next para. Thus, comma, nothing hinges on the said report simpliciter. Full stop. Moreover, comma, in the present case, comma, no legal right of the petitioner has been infringed as such for the writ court to interfere. Full stop. Next para. The reliance placed by the petitioner on Article 261 of the Constitution and Section 79 of the Indian Evidence Act are misplaced, comma, since the said provisions merely raise a presumption of correctness I'm sorry, with regard to public documents, comma, which is rebuttable in a court of law. First up, in such view of the matter, comma, there is no scope of interference in the petition. Accordingly, WPS 1720 of 2023 is dismissed without any orders to cause. Which sub next para, it is made clear that nothing in this order shall preclude the petitioner from taking all points before any forum where any dispute regarding the said certificate is pending. Full stop. Such forums shall decide all issues pending before them independently in accordance with law without being influenced in any manner by any of the observations made here. No orders to cause. Epidemiological service certificate. Yes.
Yes.
Right. What is all have been served? All of yes. Response 6. So what is that?
Your Lordship, this is a case pertaining to the withdrawal and paying for your Lordship for the withdrawal meter. The meter is relating to the person who is a prime respondent, who is not a possessor, not a leasing holder, or not a tenant. It's a just outsider and unknown to.
You cannot ask for withdrawal of a different person's meter.
No, this is quite reverse. On the basic law that the shipping property is a name Mr. Suraj Jaiswal, and I am enclosing the title deed.
Yes.
Case number 12 and extent 2.
Right.
And the legal yes, I am one of the legal yes. Legal state and enjoying the rightful possession and ownership in this sectional property. There are two meters which we all the legal yes enjoy right now. Third one, suddenly installed without intimation and permission of the landlord, which is totally unknown. And when we came to know that the person's name, respondent number 6, who is a lawful activities holder and local police. And after raising the complaint before the respondents, I know that how can he know about the complaint? Just come up my premises and pleading this and restrain me for coming to lawsuit.
According to you, he is not even an occupant of the premises.
So I just outside. And after that, I just 3 times approached to the government of registries 2 to 5. And this electricity meter which installed in our setup, annexure P3 and P4. There's a page 21. After that, when I lodged the complaint, it was On 30th August 2023, page 3.
Page
Page 23.
23, yes.
Detailing all the grievances which I raised. Then there is no further correspondence from it. Then again I complain over the telephonic conversation and which is located with the document number. That is
Ultimately, what happened to this?
no action.
So, what is the relief you now claim?
As an ad interim, I just claim
Not ad interim, and dispose of the writ petition. These writ petitions need not be kept pending. Yes. What is the final relief you have claimed?
restraining the respondent was seeks to use the meter and withdraw direct the respondents withdraw the meter.
Yes. What do you say?
We have received an application, conducted an inspection, we have found that person in position. Thereafter, he has complied with all the formalities, and we have found him to be involved in some sort of plumbing business. And he has
Some sort of
plumbing. And he has sought for a commercial meter, and he has complied all the formalities, and it has been installed as on date.
yes. What do you say? So there is a dispute.
There is no copy, sir.
We will direct affidavits. Ad interim measure. What we are wanting?
Restrain the private sector until I will defer the.
No, both of you will be restrained from using electricity in that premises. You as well as them.
I can't place the
How could they?
The persons are not.
I can come back with a report.
Do that. That will be easier. Whereas counsel for the petitioner contends that the private respondent is neither an occupier of the premises in question nor has any right to get any electricity there. First up, the property was owned by the predecessor interest of the petitioners. First up, the petitioners have two electricity connections. The petitioner has two electricity connections in the same premises, but, behind the back of the petitioner, the private respondent, who is a local hooligan, has been given an electricity connection. Question: learned counsel for the CSC Limited controverts such allegations and submits that the CSC Limited, upon due inspection and being satisfied that the private respondent is in occupation of the property, have given electricity connection to the private respondent. Subsequently, the private respondent, who is in plumbing business, sought for a commercial connection, which has also been given.
Yes, sought for commercial connection.
You have given what? Subsequently, sentence. Next one, it is submitted that the private respondent is a plumber and is enjoying a commercial connection for such business at the premises. Next para. In order to ascertain whether the CSC Limited properly satisfied itself before giving electricity connection to the private respondent, the CSC Limited shall file a short report by way of an affidavit disclosing all relevant documents and facts pertaining to the issue. Such report shall be filed, with an advance copy to the learned advocate for the petitioner on the next returnable date. The matter shall be listed under the updated matters heading on January. When should I keep it?
There are 2 weeks after vacation.
2 weeks. Report 1 week after.
I might have to go for a single search because I am suffering. I am suffering from a tendon tear.
What happened? Jim.
Something happened.
The matter shall be listed on January 12th, 2024 under the heading updated matters.
Grateful.
Holiday. 11.
Item number 3.
No email. On the prayer of the petitioner, the matter is adjourned for the given name. Yes.
Number 4. Last decision I had
Yes.
the brand has raised option, you can start the impact of the key of incumbents. I participated in the option process successful bidder paid the entire money. At the time of sale notice, it comes that the leasehold portion will be sold out. But I think that there is some basic mistake by the bank. Otherwise,
What relief have you claimed, Mr. Conway? Just remind me.
Rectification of property, the
Oh.
leasehold right, entire freehold property be transferred. The reason I indicate to the lordship, at beginning of
Achha, Mr. Conway, satisfy me on one aspect of it. Now, this, as per the latest judgments, I mean, no registration of this deed is necessary. But then this has the effect of a registered deed. You think we approach a civil court for rectification of the deed?
But it is completely upon the bank. The bank can do it. But for
Bank can do it, whether the deed court can direct them.
there is no proof required.
Very good. Let us see it. Show me your relevant proof.
Can this paper comes to the mother deed? That is the basics of the transfer.
Yes.
Page 27.
27.
Lordship says your Diamond Denmark Enterprises is the asset developer. Comes over Alco Construction Private Limited, vendor, land.
Who was the borrower?
The borrower is Manoj Kumar Anirban Engineering Private. He is the borrower. This is the same.
Yes.
Based on this, the Lordship find what kindly comes to page 30.
Yes.
Clause B, the vendor is the owner of the sale. Clause C, the assignor herein is the lessee under the vendor. In respect of such and such, but kindly travels further, not DA, clause DA, the assigner would be entitled to sublet whatever. The kindly straight away comes to the consideration. Terms over page 31. Clause E is the particular flat which is being transferred.
The sale was being effected with the assignee on it.
The assigner as well as the vendor. Assigner took certain amount of money to transfer his leasehold right.
Very.
The vendor transferred his leasehold.
Right.
So not the entire crux of the flat came in my borrowers.
Along with the title in the property as well as the leasehold. Yes.
So this was the crux of the sale.
At page 31 is that consideration which speaks about both leasehold interest and the title. Very good. Yes.
Thereafter, kindly comes to the sale notice at page 18.
Yes.
But your lordship, the sale notice not fit. As indicated by the lordship, perhaps the lordship has marked.
Yes, you had. Right.
Free from encumbrance. Remarks column, your lordship, encumbrance and other remarks.
There they say not known.
Nothing. So not encumbrance at the best would have been someone else is inducted because it's a leasehold right. Now they are seeking transfer.
But here see in the deed both of them are parties. The assigner as well as.
Everything is gone. So when the borrower had not raised this title deed with the bank in view of the loan, mortgage the property, the entire property got mortgaged.
No, this was the sale deed executed in your favor. Page 27.
30, page 27 is the sale deed of the borrower.
Borrower, right. And where is your certificate?
But my certificate is at page 56.
Very. Transferred leasehold rights.
Transfer only leasehold right. Whereas the man entire freehold property. I have spent the entire money. The lordship knows below transfer sector only 8 and 9. The bank in possession of the property has first to ascertain that nobody the property is free. If some encumbrance is found, then it has to be indicated in the auction. That is mandate. Now, not in the as per the auction notice, your lordship saw not there is nothing. Now, when at the time of transfer, the bank is transferring only the leasehold right. There is no reason why the freehold right should not be. There is no justification.
Very. Let me hear that. Yes. Take your seat, sir. Please take the microphone. Yes. Paper publication.
The property details are mentioned, and beneath the auction alert is written that all the details are available in the and in the website it was very well categorically stated that it's a right auction, and this was auctioned according to this paper.
Let us see the ad The publication, newspaper publication. Yes. Nothing else is referred to here.
Yes, ma'am, it is there.
Oh, at the bottom.
At the bottom. Clause number.
But you are putting, as per this advertisement, you are this sale notice you are putting up for sale the entire property.
The indication of property is sold. Now the auction notice matter, it's stated that this property is sold. And what is sold is written in details in the paper. And moreover, my lord, when the auction is placed, the auction details placed, everything comes on the screen, whether it's a leasehold, what is auction, everything. And the sale notice was also there, because category I have the competitors category mentioned that this leasehold right was. And accordingly, bank had issued the sale. Now, but my lord, the thing, my lord, even if the bank sold the leasehold property, by keeping the ownership right, my bank will gain nothing.
Right.
So leave that up to the lordship. If the lordship passes any order, my lord, I don't have any objection, because whatever money bank was to receive has received. So my lord, if they are, my lord, I leave entirely up to the lordship. But what bank has done, my lord, it was the ownership right was never intended to be sold. In auction notice, it was categorically mentioned that it was sold by.
No, then I'll record that you are leaving it on me. Otherwise, that will be the first ground in the appeal.
My lord, I can always leave up to your lordship. Even if your lordship records or not records.
No, what do you have to show that it was leasehold right?
Which was the leasehold and which was sold. In the sale notice, which was available on the website, upon which this sale was done. When the lordship comes to.
Have you got a copy of this also?
Yes.
Give one to Mr. Cotton.
No, extra copy. Now, can we come to page 3? And clause number 12. You know, numerous places mention the only leasehold rights. Page number 3, the third page. I think it's printed also.
Yes.
Clause 12. The
And
same leasehold right.
In the second clause itself also. In the
Yes, numerous places it mentioned. So it was always intended that leasehold right was mortgage. It was always intended that leasehold right would be sale. But never I leave it up to the lordship, because my bank will not gain anything by keeping that ownership. So I do not want my that.
Either you said bank is agreeable then.
No, I have instructions not to press a lot, but what is the fact to place before your lordship?
Good. Learned counsel for the petitioner contends that in a notice of an auction sale conducted by the respondent bank, comma, it was disclosed that all that part and parcel of commercial unit at Diamond Prestige, comma, room number 703 hyphen capital A, comma, 7th floor at 41 capital A, comma, Acharya Jagadish Chandra Bose Road within bracket AJC Bose Road bracket closed, comma, Kolkata 7,17,000, comma, having built up area 2313 square feet within bracket super built up area 3084 square feet bracket closed, with right to park one number of car in the lower basement bearing number 043 and one number of car in the upper basement bearing number 028 belonging to the borrower was put up for sale. First up, in the encumbrance column, comma, it was mentioned that no encumbrance was known to the AO within bracket authorized officer. First up, now, first up, comma, apart from a claim of rupees 4,46,747 as on November 9, 2021 towards outstanding dues of maintenance and electricity charges from an entity mentioned there. First up, however, comma, when the sales certificate was issued in favor of the petitioner, comma, pursuant to the petitioner depositing the entire consideration amount, comma, it was discovered that only leasehold rights in the property had been severed in favor of the petitioner. First, it is argued that the same was palpably contrary to the sale notice of the bank, which after having deposited the entire the consideration pursuant to the sale notice, comma, it is argued that it is incumbent upon the bank to sell the entire property, which as such, comma, the petitioner seeks a rectification of the sale certificate to the effect that the entire title in the property be transferred to the petitioner and not merely leasehold rights. Full stop, next para. Learned counsel for the petitioner also relies on the relevant clauses of the parent deed executed in favor of the borrower, comma, where not only the title and not only the leasehold interest in the property was sold by the assigner, comma, the entire ownership stroke reversion was also transferred in favor of the borrower. Full stop. Next parallel. And counsel appearing for the bank submits that in the auction notice itself, comma, it was mentioned underneath that for detailed terms and conditions of the sale, comma, the link provided in the official portal of the bank is required to be looked into. Full stop. Learned counsel hands over a printout of a document indicating that in the uploaded copy, comma, it was categorically mentioned in several places that the leasehold rights in the property was only to be sold. Full stop. Next para. However, comma, it is also indicated that the bank has both the leasehold and the leasehold interest and the title in respect of the property, and otherwise there is no difficulty if directed by the court, comma, to execute any deed of rectification. So next pair. A perusal of the auction notice clearly shows that the bank, comma, in unambiguous terms, comma, offered for sale the entire property, comma, by indicating that no known encumbrance existed in respect of the property apart from a claim of a particular quantum of amount in lieu of maintenance charges. Full stop. Next para. Although, comma, in small print, comma, it was stated at the bottom of the said notice that for detailed terms and conditions of the sale, the link provided in the concerned website was required to be visited, comma, visiting the said link was not a mandatory part of the notice. Full stop. Moreover, comma, by way of a reference to a tertiary website, tertiary, TERTIARY, tertiary website stroke document, comma, the principal terms of the auction sale notice cannot be altered. Full stop. Next para. Thus, comma, what was put up by the bank was the entire property, comma, including leasehold rights as well as title, comma, as owned by the borrower himself and which was a part of the secured assets. Full stop. Hence, comma, the bank cannot resign from such position now and sell only the leasehold rights in the property to the petitioner. Full stop. In such view of the matter, comma, the petitioner is entitled to a rectification of the sales certificate on the part of the bank. Full stop. Accordingly, WPO 1765 of 2023 is allowed on contest, comma, thereby directing the respondent number 1 bank to rectify the sales certificate dated August 11, 2022 by incorporating the transfer of complete ownership along with leasehold right in respect of the property in question in favor of the petitioner. Full stop. A fresh rectified sales certificate shall be issued accordingly by the bank at the earliest, comma, positively within 3 weeks from date in favor of the petitioner. No address to cost. Oh, rectification deed kotha boliche to control file korna rectification certificate.
And one more thing, Lordship has observed that there was no obligation for him to see the bank print and book, etc. There it was done. So
Where is it?
the sale will be conducted online. So without going, it cannot be.
Finding. Finding of court, not your submission.
Item number 5.
Yes. Right. So now for the other side. Yes. Yes, Ms. Banerjee, what is it?
This has come after the review committee's order. The order of review committee is also according to me that the initiation of the proceeding was also bad for 3 reasons. Number one, is that the show cause notice is based on completely a forensic audit report, which is inconclusive document with various disclaimers. That was not used by the NCLT. This is number one. The writings from the forensic audit report has been copy pasted in the show cause notice. Thereafter, in the identification committee's first order, and subsequently by the review committee. Completely, no paraphrasing, also completely lifted. Number 3, after receiving the show cause notice, I had given a written representation. There is non-consideration of that representation by the first committee. I had given annexures also to my representation. No reflection of that in the first order. Also, pursuant to orders, I was given liberty to give a representation before the review committee also. That also, though referred to in the order, the dates, there is complete non-reflection of consideration of those representations. And the personal hearing was given by the identification committee, but no submissions have been recorded. Nothing what I have said, or I was not even allowed to speak. Now, the circular says, first committee must consider my submissions and then make the order. And the review committee thereafter, also.
Yes, Mr. Naik, file your opposition. I'll stay the order till a particular period. I'll record the grounds. Prima facie case. The petitioner has made out a prima facie case for hearing the writ petition on merits, primarily on the following grounds: next para. The show cause notice issued by the willful defaulter identification committee. No, that's sorry. First point, the show cause notice issued for declaration of the petitioner as a willful defaulter was based entirely on a forensic audit report with bracket FAR.
I understand. Possibly an opportunity being handed up to me, but I don't think that additional documents are bringing.
You want a hearing on this?
I can't supplant it, supplement it. It is what it is. So I would have to argue it on the merits.
What is your defense?
So the defense could have 3 points. Also, I understand extremely gracious of your virtue, but I'm letting go of that because that would be my instruction. On the point of the show cause notice, admittedly, it's based on a forensic audit report. I understand that it's an inconclusive document, several disclaimers. But my point of submission would be that an inconclusive document with a disclaimer will not preclude me from initiation of proceeding. It may preclude me from reaching a conclusion exclusively based on the forensic report because there's a disclaimer. I cannot argue anything contrary to that. But if I have a forensic audit report, whether the NCLT has taken cognizance of that or not, I can base that for the initiation of a proceeding by one of the show cause.
Let us see the show cause.
And it comes to page 61. But you kindly look at the first portion of the paragraph towards the bottom. This is right before the above mentioned clause. This much looks at 4 sentences from the bottom. As per direction of the NCLT for incident, towards the end of the sentence, 4 sentences from the bottom. Towards the right hand side.
Bottom is above mentioned.
Above mentioned. Yes. 4 sentences.
Now the committee for identification has identified.
Because the paragraph due to non-service of debts. Page 61. Wait, what you looks at the third paragraph.
Due to non-servicing of this. I've got it.
What you looks at the next sentence.
Yes, an application.
An application, then section 9, primary operation creditor, MS sheet Vishwandas iron was before the Honorable NCLT Kolkata Vijay CIG decided, COC decided Shantanu Brahma as RP as per direction of NCLT for an audit report. For an audit was conducted by BCP and Associates. Report submitted on 18th of March 2020.
There is no disclosure of the grounds on which you have.
So there is. If you look at the next page, starting with enrollment explanation. These are the grounds that we set up. So even if there is a forensic audit report, we have set out afresh whatever grounds of show cause that there is. They were required to respond on this. Based on this, they give a response. Based on that response being considered, they were given a personal record. There were adjournments that they all form a part of the identification committee order, which is on page 224. So it is not that we say that there is a forensic audit report, just for clarification of we don't say that there is a forensic audit report, we respond to all the allegations that are findings of forensic audit report. I reproduce these grounds, so that I take cognizance of the forensic report. Then there is a show cause. So the forensic audit report at this point becomes inconsequential in my sense. Because I reproduce them.
What are the independent documents on which you rely, or whatever? In your first committee report order, please. 224, yes, it starts.
24, 31st of May, they get service for 26, 29th of April 2022.
Yes, hearing was given.
Yes.
Mr. Naik, please just show me what independent documents or materials apart from the FAI you relied on. Show me that one.
But it comes to the bottom of page 227.
227 bottom, yes.
Diversion, these are the allegations which should be.
Yes, yes.
The auditor analyzed invoice from the Indonesian core sold three sales, overseas limited invoice number sold and related sold. Build quantity sold as whatever quantity.
Please start from the paragraph immediately preceding that, Mr. Naik.
The acts of the company, its promoters, the directors, and personal corporate directors coming under the purview of RBI guidelines and identifying willful defaulter as per findings of forensic audit submitted by.
And in that context, it is stated auditors analyze, means the forensic auditor.
Yes, and on the basis of the response that they give. So these were kindly appreciated.
So the entire basis was that forensic audit.
The findings with respect to the amounts and accounts.
What is the independent document apart from the forensic audit report to substantiate your claim? The other allegations.
With respect to identity quantification, with respect, so these are conclusions that I arrived at.
What is the reflection of their points, their representation to you in this order? In the orders, there must be some reflection that they said this. Everything based on auditors. See, go on seeing Mr. Naik, page 231, middle and auditors selected one item. Entire thing is, it's totally based on that auditor's thing.
There was a representation.
So all the grounds are substantiated. Their grounds, not the allegations against them. It's a very difficult job nowadays to defend these and look outside. It's a very difficult job. Now, I don't want to make it more difficult for you. You have your case before you. You convince yourself, Mr. Naik. There was some.
I've gone through.
Convince yourself, yes, obviously.
There's a factual assertion that I made. There's a representation that they give. All I can see is possible.
So you didn't want to draw the agony further by asking for evidence.
I understand.
Fair enough.
Also because in law I can't supplement this.
No. Definitely.
There is there. It's not wrong. I can't waste the time of people also there. But having said that, I can only say it's not really drafted. But the factual assertion is based on representation. I can only say that they've been taken into account.
These may be true also, Mr. Naik. We don't say that these are true or untrue. We cannot say that at this stage.
If this was
on the list
passed by a civil court, I would understand that the order would have to test a higher degree of rationality. I'm not defending it to the extent that's not happening. It's number one, it's the judicial order. The administrative order more or less being decided in jar level.
That is what happens once you relegate these things to administrative authority.
Administrative authority.
If you relegate the judicial activities or quasi-judicial activities to administrative people, this happens. Naturally, they are not trained to do that. They may be very good in their own banking work, or other administrative functions. They may be very good. We can never match them, obviously. We are not trained for that. But this is what happens if you do this.
But this wouldn't suffice for their case to establish this unreason. That is my only view. The only test for interference under the 226 code is for them to demonstrate that it's an unreason. If my
No, there are other tests. I'll put that in.
I understand unreason. The Whirlpool gives that series of, but my learned friend will have to take the lordship through their representation, and one by one she'll have to say that these are not being taken into account.
Onus is the other way around.
I can't prove the negative. I'm saying that we have to. We are saying that
You have not proved the positive. But does the onus shift? When does the onus shift? It's your burden to substantiate the claims.
Exactly. So
everything goes.
But in my understanding,
House of cards.
It's false. I understand there's only so much that I can defend this. But having said that, there are really because I haven't used the phrases that a court would otherwise take into account.
Not the phrases. Mr. Nag, not the phrases at all. I'm not on the phrases at all. The materials, independent materials, apart from that forensic audit. I was looking for that. There is nothing. You have to work a bit more to implement people.
Look, Lordship kindly appreciates this. I understand. I'm not defending the quality of thing. I'm only saying this. Today, I have carried out a Lordship kindly bear with me trying to go. There's a forensic audit report that has been drawn. Now, the forensic audit report may not be the basis of the declaration of a person as a willful defaulter, but law is clear because of the disclaimers in it, because anybody of any standard accountant, any cost accountant of some merit would put in that disclaimer because they will also not take that responsibility. And that is what the law stands as. Having said that, today that can very well be the ground for initiation of the proceeding. The burden now shifts to them to come and show that whatever the factual assertions were made in the show cause notice, not the forensic audit. Whatever were the factual assertions which were made in the show cause notice, they be disproved. So factually, they have to come forward by way of representation of an defense client has done that. They have come forward. But when they've come forward, all that is before the committee, these are the facts that are there and the assertion of the forensic audit report that this is true. So you disprove it. You disprove and say, so there are, if I can give examples of the
take your seat rather than giving examples. Please take your seat and hear what you say.
The other point, the review committee also was not constituted.
I
didn't. I want.
That's
I'm not
excellent, sir. Excellent case.
This is the same
Case is cut and dried for you.
You must know that this has been passed. I don't use the same submission that it's on their behalf or whether
Learned counsel for the petitioner throws a challenge to the show cause notice issued against the petitioner for declaration of the petitioner as willful defaulter, as well as the orders of the willful defaulter identification committee within bracket first committee bracket close, and thereafter the review committee. The committee will have now short capsule. Review committee RC, willful defaulter, everything capsule. Question. Next paragraph. It is pointed out that the show cause notice itself practically, please take your seats on, practically quoted a forensic audit report, FAR, bracketed FAR, which itself was inconclusive. Full stop. Next para. The petitioner duly gave representation to the first committee as well as to the review committee, comma, none of the contents of which were reflected in the orders of either committee. Full stop. Both the committees, comma, it is argued, comma, placed reliance blindly on the forensic audit report and came to the conclusion that the petitioner was required to be declared as a willful defaulter. Full stop. It is argued that as such, comma, the same vitiates not only the show cause notice but the subsequent orders of both the committees. Full stop. Next para. It is further argued that the review committee was constituted unlawfully, comma, rehearsed the provisions of the concerned master circular on willful defaulters issued by the Reserve Bank of India. Full stop. Next para. Learned counsel for the bank contends that although the show cause notice referred to the forensic audit report as its basis, comma, the independent allegations quoted from the quoted from the said FAR in the show cause notice were required to be rebutted by the petitioner by cogent evidence, comma, which has not been done in the present case. Full stop. Next para. It is argued that the review committee was duly constituted, but the order was communicated only by a person, by the zonal manager, by the by the
Zonal head.
by the zonal head of the bank. As such, the argument that the committee was not duly constituted is refuted. Next para. Upon a consideration, have you annexed the forensic audit report?
Yes, I have.
Great. A, con- a consideration of the materials annexed to the writ petition indicate clearly that the premise of the show cause notice and the subsequent orders was essentially the forensic audit report, which was allegedly not accepted by the National Company Law Tribunal in a parallel proceeding. Next para. The forensic audit report, as is evident from it, was not only inconclusive but full of disclaimers, which rob the same of any conclusive value. In any event, the forensic audit report would at best be a piece of document which would initiate a further detailed inquiry by the respondent authorities prior to declaring the petitioner to be a willful defaulter. The same having not been done by the respondents, the impugned orders as well as the show cause notice are vitiated. Next para. The inconclusive forensic FAR would not be a premise of the show cause notice. In fact, the show cause notice, apart from putting the provisions and observations in the said FAR, would not independently make any allegations of particular acts done by the petitioner. Next para. More importantly, neither the first committee nor the review committee considered the answers given by the petitioner in the petitioner's representations to both the said committees. Next para. Also, the premise of both the committee orders was the FAR itself. Since the FAR was inconclusive and filled with disclaimers, as rightly contended by the petitioner, in the absence of any further independent material to indict the petitioner on the allegations as made in the show cause notice and the said orders, both the committees acted towards the master circular and law in declaring the petitioner to be a willful defaulter. Next para. Moreover, the contention of the respondent bank that the order that the document annexed to the petition as the order of the review committee was a mere communication by the zonal manager of the bank is not tenable, since the said document is clearly the order itself and not a mere communication. In view of the review committee being improperly constituted vis-a-vis the directions of the master circular on willful defaulters, the order of the review committee is rendered a nullity as well. In such view of the matter, the show cause notice as well as the subsequent orders of both the committees do not survive the scrutiny of law. Accordingly, WPO 1776 of 2023 is allowed in contest, thereby setting aside the impugned show cause notice and the orders of both the willful defaulter identification committee and the review committee declaring the petitioner to be a willful defaulter. Next para, no orders to cause certain certificate copies. At the outset, it is submitted by the counsel for the bank that in view of all the necessary documents being annexed to the writ petition, the bank does not want to use any affidavit in opposition to the writ petition. Accordingly, no affidavits are directed. However, it is deemed that none of the allegations made in the writ petition are admitted by the respondent.
further than clarify dispute preclude us from initiating a fresh proceeding.
Nothing in this order shall preclude the respondents from initiating a fresh proceeding for declaration of willful defaulted against the petitioner, comma, if done in accordance with law.
Number 6.
Yes, please.
Numbers.
The affidavit, sir. Yes.
Clean numbers.
Right.
Because of the petitioner, they have applied for issuance of their passport and those were rejected.
Reissuance.
Reissued. On the ground, possibly the criminal case was pending. Last time was the same thing. They said criminal case was pending, now it's not it can't be done. Now let's wait where Roger could come to the order passed when I did the earlier rate petition appearing at page 111.
Yes.
The order number by which the rate petition was allowed. May I?
Yes.
The petitioners are agreed. May I?
Please.
The petitioners are agreed by an order of the Deputy Passport Officer dated also by which the petitioner was informed that the office is not in a condition to issue the passport since the criminal case is pending against him. The order does not specify the nature of the case. The order to say that the petitioner may apply to the court for permission as far as the conditions of notification. So also with an undertaking that the petitioner is going to be processed according to the order of the court. Next, section 6(2) F of the passports 1967 deals with the refusal of passport or to travel documents and provides that subject to the provisions of that the passport authority refuse to issue the passport and travel documents to a person for visiting any foreign country on the ground of the proceedings directed of an offence of pending criminal court in India. The notification dated so and so which was referred to by the passport officer makes it clear that the central government decided to accept citizens against whom proceedings are pending from travel restrictions involved. The notification makes it clear that the pending proceedings are those in the court and that the conditions in the notification are with reference to section 6(2) F of that. Clause E of the notification provides that the citizen shall give an undertaking in writing to the passport issuing authority that he shall, if required by the court concerned, appear at the time during the confidence force of the passport to issue. Clause A makes it clear that the passports are to be issued where the condition provided in the notification include that the court may specify a period for which the passport is to be delivered considered in this court allowed and said passport will have to be issued for a period of 1 year subject to India. I get it was done. Now, this when I get an application for entire passports returned, may I show the 3 application names before the passport authorities finally come to page 115. There are other orders also. I am not placing page 115. I will see the applicant's name. Then reissue what you will find. First, for the service required applying for
Reissue. Yes. Yes.
Now, the only thing what I can see were held with or hold with appointment. What does it mean? Then the petitioner, another petitioner, 121.
Mr. Dev, have you obtained an order from the jurisdictional criminal court?
That is not required. Not required.
Please come to that notification.
Yes, I will. I will not have it before that.
6F. 6(2) F. Passport Act.
I have not.
No, not that.
Okay.
That is better. If I were the authority and this book was cited, I would have 6(2) F.
6(2)
Right. Thank you.
Yes. Refusal of passports from the document section starts with that. 6(2) says subject to the other provisions of this act, the passport authority shall refuse to issue passport or travel document for visiting any foreign country under clause C of subsection 2 of section 5 or any one or more on the following grounds and on no other grounds, namely, only come to F. The proceedings in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India. So that's the bar it says.
Which has been diluted in the notice. Let us come to that.
But they will.
Must have been annexed here. Anyway, I'll look into this. You have to read the first page, Mr. Dev. The very first page.
Yes.
No, turn the first page. Yes, read out.
It's in
Yes.
translated is blood.
No, Hindi is also an official.
That's true, but I have some difficulty reading.
Start with that.
Understanding is okay, but reading will some difficult.
Let us come
That's
to
what they use version. Ministry of External Affairs notification dated 25th August 1990. GSR 570 in exercise of the powers conferred by Clause A of Section 22 of the Passports Act 1967 and in supersession of the notification of the Government of India in the Ministry of External Affairs number GSR so and so dated so and so, the central government being of the opinion that it is necessary in public interest to do so, hereby exempts citizens of India against whom proceedings in respect of an offence alleged to have been committed by them are pending before criminal court in India and who produce orders from the court concerned permitting them to depart from India from the operation of provision of clause F of subsection 2 of section 6 of the say that subject to the following conditions. Now, what are the conditions?
No, before going into the
Yes.
two things have to be there. In public interest, what is exempted? Hereby exempts citizens of India. Two criteria are to be fulfilled. Against whom proceedings in respect of an offence alleged to have been committed by them are pending before a criminal court, one, and who produce orders from the court concerned permitting them to depart from India. Only in case of those persons it is exempted. If a criminal proceeding is going on, you have produced an order from the criminal court. Rest of the portion qualifies that. If it is 1 year, if the order says 1 year, then it has to be, or if time is stipulated in the order, it has to be that period for which the passport is issued. If nothing is there, by default, it's 1 year. The rest qualifies it. But the precondition is proceeding pending, you have to obtain an order from the criminal court, which is qualified by the period is provided in the riders. So, Mr. Dev, you just obtain an order from the criminal court and the rest will follow. I've been hearing these matters, several matters like this. So this was placed before me many a time. So the requirement is not these riders. The requirement is you have to get an order from the jurisdiction. The riders say yes. No, the riders say that yes, whatever is the period stipulated in that order, that is the determinant. Passport will be for that period. Otherwise, one.
Then the conditions.
Then rest follow. The rest are regarding only the period. By default, 1 year if no period is stipulated. If period is stipulated, that will have to be honored by the. So obtain an order, I'll give you that limit. And I'll stipulate a time limit within which if you apply, if you have any urgency. Do you have any urgency? What is your urgency?
Business, Bangladesh.
Anyway, we can think about that, putting in a rider regarding the time. Similar orders I found from the same coordinate bench, but this was not placed before her leadership.
So this matter is concerned about since I appeared and placed in the provision.
That order you missed out. That order from the criminal.
I will come to page number
112, yes. Yes. I'm not saying that it's subsistent.
No, I know. Now, the thing is last they say that
whatever they say, I'll give you leave. If you obtain that order from the criminal court, they're bound to give you passport.
I will protect you to that because
Definitely.
Last time what they said, I'm not going to issue the passport unless you get an order of court. Meaning thereby well which court or the but I got your lordship.
That is the difficulty. In all these matters, that is the common misconception of all the applicants.
So far as reason number 1, reason number 2, there is dual necessity other answer. But so far as reason number 3, how he is coming joining the reason number 1 and 2?
Who is Lal Babu Mullah?
All three put and forward their is related.
If necessary, then it will
File separate application.
No, put in the additional quote.
yes, it will do.
No, for all these 3%, because they are wanting separate passport. So even if there is a joint relationship, you have to put in the additional code fees.
Yes,
Put in it by two. Yes, definitely. Yes. Satisfy him first. Learned counsel for the petitioner contends that the petitioners sought for reissuance of passports to them. However, the respondent authorities have been withholding the same on grounds unknown to the petitioner, despite and that order was passed by the coordinate bench in this matter, in your matter.
Actually, earlier.
Same three were the
Right.
identical grounds, only additional thing they turned down, you not they returned the entire bunch.
Despite there being an order of a coordinate bench in that regard. Next paragraph. Learned counsel, by placing reliance on the said order, contends that the respondent's authority are bound by the same to issue the passports to the petitioners. Next paragraph. Learned counsel, appealing for the respondent authorities, places reliance on the concerned notification dated August 25, 1993, issued by the Ministry of External Affairs, Government of India. It is. You want to add anything? Yes,
Provision would have also because about issuing the passport. Now, when the passport has been issued,
Reissuance means you extension. No, at the initial juncture there was no criminal case.
Yes.
When the passport was issued in the first instance, there was a criminal case. This notification was there. When was the passport first issued?
First time it was issued for October 2020. First when the order of the court paid 118. Paid 118. I will see the date.
But 6th comes in.
6th comes in.
6th now it has been considered. There is a legal bar now.
It was issued on the reason given by someone. It is for a period of 1 year.
No, make out this point properly.
Yes. Initially, passport was issued for 1 year.
Pursuant to this order of the coordinate bench.
Yes. And showing the notification to see the date. And 118. I will come.
Yes.
Let me say. Read 118. I will see the date. November 2020. And till 31st October 2023. Criminal case was pending. They appear. Now, after expiry, I'm applying for reissuance. And the fact that the criminal case was pending.
Is there any specific provision for reissuance or renewal?
Notification clause C. A, B, and C. But maybe page 24 of the
No, Mr. Theory, if a passport is issued in terms of A above, then it can be renewed under the same provision.
Yes.
But here the passport was initially not issued under A. It was issued in an unqualified manner.
The issue on the relation given by this one. Can you see let me place note A. The passport to be issued to every citizen shall be issued for a period specified in the order of the court referred to above. If the court specified a period for which the passport
No, this issuance is renewal is only in respect of passports which have been issued under A. Here his passport was not issued under A.
One thing I probably should have pointed out. Kindly come to page 1.
No, I want to see the renewal.
113 not kindly considers on what ground I was giving the passport. That I will appear regularly. Kindly see, I should have placed it. I think this page I did not place. On such condition, upon furnishing an undertaking, this was given.
for a period of 1 year.
What was
That's not issue.
valid? And how
Such issue for
for issuance of that for 1 year?
I want to see whether the renewal clauses, the same trappings apply to renewal also.
So far as renewal clause is concerned, I see there are two clauses. Number one is B.
B.
B is saying
B of which?
B of this notification number GSR 570.
Yes.
Clause A. There are courts.
No, in the Act, in the Passport Act, I want to see whether the same conditions apply. This is a question of applicability of 6(2)(f) itself. If 6(2)(f) applies, this applies.
6(2)(f) says
6(2)(f) is very clear. You have to go up to 5.
Yes, sir.
Find out if there is any separate clause for renewal. Extension page, section 8 probably.
Extension of period of passport, section 8. Conditions on the
Yes, I was wanting this. And the provisions of this act shall apply to such extension as they apply to the issue there. Therefore, Mr. Dev, by necessary implication, 6(2)(f) also applies. If 6(2)(f) applies, then that also applies.
It's a fresh application.
Yes, the modalities apply as a fresh application. I had read something regarding this because that was a challenge to a passport non-issuance. I'll read that into this. Otherwise, Mr. Dev, this has no meaning. Because otherwise, suppose a passport is issued, subsequently a criminal case is levied against you. Now, then this will not apply. Why are you a privileged citizen?
Things.
When did your criminal case start? In your case,
Started before
2011.
Now the thing is, after saying this, the question here as and when that particular clearly qualifies or takes charge of it, I see once for it.
Does not override this.
Cannot. Obviously, I will not never say.
Yes.
The petitioner shall order an undertaking and authority shall appear before the court at any time, as and when court required in such proceedings. Possibly Article 21, and considering this court as this
But Mr. Dev, that has to be done. That exercise has to be done as per this notification by the jurisdictional court. And why should this rider be there? If the jurisdictional court says that is 1 year, I give you 1 year, then you are entitled to unqualified visit of expert.
Jurisdictional court does not.
No. You are mistaken on that. Several orders are passed giving this liberty. It's like the similar considerations as a bail. Similar considerations as a bail. I mean, it has to be taken care of. I mean, whether this can be done. If that is refused, that is a fresh coverage. That's a fresh coverage. We always have that liberty to check. I will do whatever I was doing, but I record this.
No, I'm sorry. Rochi was doing absolutely.
No, not that. No, I'll do that, but I'll record with your additional submission that this was done during pendency of the criminal proceeding, which also has to be dealt with by.
Learned counsel appearing for the respondent authority places blank on the consent notification dated August 25, 1995.
Issued by Minister of External Affairs, Government of India. Pushed up in the said notification, comma, exemption has been granted to citizens of India against whom proceedings in respect of an offence alleged to have been committed by them are pending before a criminal court in India and who produce orders from the court concerned permitting them to depart from India. Pushed up, it is submitted that in the present case, comma, no order has been obtained by the petitioner from the jurisdictional criminal court and, comma, as such, comma, passport would not be reissued in favor of the petitioners. Pushed up, next para. Learned counsel for the respondents also takes a preliminary objection as to a single writ petition not being entertainable at the behest of 3 separate petitioners having 3 separate causes of action regarding their individual passports. Pushed up, next para. In reply, comma, learned counsel for the petitioner submits that the petitioners are agreeable to put in additional court fees befitting 3 separate writ petitions. Pushed up, next para. On merits, comma, it is submitted that even during pendency of the criminal cases against the petitioners, a coordinate bench had directed on September 28, 2022 in WPO 2633 of 2022 to issue passports to the petitioners subject to certain conditions being satisfied by the petitioners, pursuant to which passport had been issued by the respondent authorities without adhering to the rigor of the notification in question. Full stop. Learned counsel for the petitioner raises a question as to whether, in view of the original passports having been issued in the teeth of the notification, at the juncture of reissuance/renewal, the said notification can be cited to refuse reissuance. Full stop. Next paragraph. With regard to the preliminary objection, the same can easily be taken care of by directing the petitioners to put in deficit court fees within a limited period as directed by the court, equivalent to 3 separate writ petitions in total. Full stop. Undoubtedly, the 3 writ petitioners canvass separate causes of action for which such course of action would suffice. Full stop. Next para. Accordingly, the petitioners are directed to put in additional court fees equivalent to 2 other writ petitions by 48 hours from now. Full stop. Next para. In default, the order which is proposed to be passed herein shall stand automatically vacated. Full stop. Next para. Insofar as the argument of the petitioner is concerned regarding the passports having previously been issued in their favor pursuant to the direction of a learned single judge of this court without adhering to the rigors of the notification, the same simpliciter cannot be a ground for the petitioners claiming similar relief at the juncture when a reissuance of the passports have been sought. Pushed up. Next paragraph. The matter pertains to the applicability of section 6 within bracket 2 within bracket small f of the Passports Act 1967 and its interplay with the notification cited by the parties. Full stop. Next para. Section 8 of the 1967 Act clearly provides that where a passport is issued for a shorter period than prescribed under section 7, the said period shall, unless the passport authority for reasons to be recorded in writing otherwise determines, be extendable for a further period as stipulated therein, and the provisions of the Act shall apply to such extension as they apply to the issue thereof. Full stop. Next para. The expression within double inverted provisions of this Act shall apply to such extension as they apply to the issue thereof, double inverted clause, clearly indicates that for all practical purposes, all modalities applicable to initial issuance of a passport are also applicable at the juncture of renewal/reissuance of passports. Full stop. Hence, in the present case, section 6 within bracket 2 within bracket small f as well as the notification concerning the same both apply to the reissuance of passport by deeming the same to be a fresh issuance of passport. Full stop. Next part. Insofar as the order dated September 28, 2022 passed by the coordinate bench is concerned, it is seen that the petitioners were directed to furnish undertaking in writing to the passport authority that the petitioners shall appear before the court concerned at any time as and when required in such proceedings. Full stop. Next para. Thus, the premise of the learned single judge was more on the basis of a vindication of the right to life of the petitioner as well as right to freedom as enshrined in Article 21 of the Constitution of India, subject to certain riders being put in for issuance of passport to the petitioner. Full stop. Next para. Although the notification in question was considered, the specific rider therein as to an order from the jurisdictional court being mandatory to get the relief under the said notification did not fall for consideration or was argued before the said court. Hence, insofar as the applicability of the said rider in the notification is concerned, the said judgment, with utmost respect, is not a precedent on such issue. Next paragraph. The notification in question clearly provides that an exemption is granted to citizens of India against whom proceedings in respect of an offence alleged to have been committed by them are pending before a civil court, before a criminal court, which is squarely under the contemplation of section 6 within bracket 2 within bracket small f of the Passports Act 1967. The exemption granted, however, is subject to the rider that such a person shall have to produce orders from the within double inverted court concerned, double inverted close, permitting them to depart from India. Next para. The expression double inverted court concerned, double inverted close, has to be read with reference to the expression within double inverted criminal code, double inverted close, used in the previous portion of the said clause of the notification. Thus, the order which is to be obtained permitting the applicants to depart from India is to be obtained from none other than the jurisdictional criminal court where the criminal trial against the said applicants are pending. Next para. The subsequent riders in the said clause only speak about the tenure of such passport. The subclause small a within bracket I speaks about the order of the tenure of the passport, in case the criminal court has specified a particular period, to be co-extensive with such period. The rest of the subclauses in the said provision only stipulate that the default period of issuance of passport otherwise is 1 year. Next para. The same has to be read in conjunction with section 6 within bracket 2 within bracket small f, which provides that the passport authority shall refuse to issue a passport or travel document for visiting any foreign country under clause small c of subsection 2 of section 5 on any of the conditions, including that proceedings in respect of an offence alleged to have been committed by the applicant are pending before a criminal court in India. Read in conjunction, section 6 within bracket 2 within bracket small f, and the notification mandatorily stipulates that to get the exemption under the notification, if a person is covered by a pending criminal case as envisaged in section 6 within bracket 2 within bracket small f of the Passports Act, the person has to obtain an order in that regard from the criminal court permitting him to depart from India. In the present case, admittedly the petitioners have not obtained any such order as yet, thereby justifying the refusal of the passport authorities to reissue the passports on such ground. However, in the event the petitioners do obtain such orders from the concerned criminal courts, there is nothing to prevent the petitioners from being granted reissuance of their passports. Next para. Accordingly, WPO 1778 of 2023 is disposed of by granting liberty to the petitioners to apply before the concerned jurisdictional criminal courts for an order permitting them to depart from India as contemplated in notification being notification number GSR 570 within bracket capital E dated August 25, 1993. If such applications are made within a week from date, the concerned criminal courts shall decide on such applications within a further week thereafter by acting on server copies of this order without insisting upon prior production of certified copies. Full stop. Upon obtaining such orders from the criminal court, comma, if so allowed, comma, the petitioners will be at liberty to reapproach the passport authorities for reissuance of their passports. Full stop. In the event such orders are produced by the petitioners before the passport authorities, comma, the passport authorities shall decide the uh, applications of the petitioners for reissuance of passport afresh in the light of the said orders obtained from the criminal court, comma, positively within a fortnight from the date of such approach being made with the copies of the criminal court's orders. Full stop. No orders to cause service.
Let's see. The কতগুলো হাত প্রভাবই ভোকালের সময় যে পিটিশনটা তত থ্যাংক ইউ
My advocate record is very good.
পেছনে অ্যাসেসমেন্টটা দেখলে আমি বলে দিলাম
Thank you.
Last time he had, so he didn't take any
2 to 3 করা
Yes, but difficulty is to locate that portion.
Absolutely.
What absolutely?
The way
Play again.
the way you
Thank you.
dictated now, find it out and again.
No, very well. After na, after তলার নোট দিয়ে দিতে তলার নোট দিয়ে দিতে হবে যে কোর্স is already checked. I'll incorporate this.
Grateful.
Don't have to think. Yes.
Item number 7.
Yes, please. Right. Respondent. The number? Yes. What is the matter?
The petitioner is a widow of a deceased employee of Legislative Assembly died in 25th May 2023. Whereafter death benefits while death benefits were being processed, the petitioner was directed to open an account in the correspondent bank, one bank. And after opening of the bank account, the death benefit like pension gratuity were being submitted, deposited in that account. Suddenly, some amount of the payment was also withdrawn by the petitioner. Suddenly, at page 13, your lordship, at page 14, your lordship will find at the bottom when there was almost 1 lakh some balance left, the account was frozen. Thereafter, the petitioner made a representation at page 15 asking for clearing of the freezing. When the petitioner was served with a letter at page 16 that some amount of money was taken on personal loan by the employee, deceased employee during his lifetime, and for that reason he was directed at page 17 per last paragraph that unless that payment is made, the amount will be deducted from the account. Your lordship is well aware that these benefits are not even attachable for decree also. Therefore, I made a representation, and the representation at page.
You want a defreezing of the tax?
Yes.
Is for the bank. Good service on the bank. Have you checked?
Not.
Despite service, none appears for the respondent bank. Full stop. Next paragraph. The petitioner is the unfortunate widow of an employee of the State Legislative Assembly who met his demise on May 25th, on May 25, 2023. Full stop. Thereafter, comma, the death benefits and pension of the petitioner was being deposited in an account opened by the petitioner with the respondent number 1 bank. Full stop. However, comma, subsequently the said account was frozen by the bank. Full stop. Upon inquiry, comma, the petitioner learned that the said freezing was done on the allegation that the deceased husband of the petitioner had taken a personal loan but had failed to repay the same. Full stop. Learned counsel for the petitioner contends that even in execution of a decree as contemplated in section 60 of the Code of Civil Procedure, comma, gratuity and like benefits cannot be attached. Full stop. Hence, comma, the action of the bank is challenged before this. Full stop. Next para. Learned counsel for the petitioner is absolutely justified in arguing that even the higher action of execution of a decree passed by a competent civil court cannot be executed to attach the gratuity and pensions of like nature in terms of section 60 of the Code of Civil Procedure. Full stop. That apart, comma, in the present case, comma, the bank does not enjoy any lien over the pension to be paid to the petitioner as widow of an ex-employee. Full stop. Next para. The bank, comma, without initiating any appropriate proceedings for recovery of the amount or making a demand to the petitioner, comma, adopted a high-handed mode of action in directly freezing the account of the petitioner, comma, that too, comma, the pension account of the petitioner, which is palpably divorce the law. Full stop. It has to be taken note of here that the pension payable to the petitioner and other debt benefits of her husband are not property which is inherited by the petitioner from the estate of the husband, but an independent right of subsistence provided to the dependent heirs of a deceased employee. Full stop. Thus, comma, the right to get the pension is an independent right of the petitioner, comma, albeit in the capacity of the widow of the deceased employee, comma, and not a part of the estate of the deceased as such. Full stop. In such view of the matter, comma, the impugned action of defreezing the petitioner's pension account does not stand the scrutiny of law. Accordingly, WPO 1785 of 2023 is allowed, comma, thereby setting aside the impugned decision of the respondent number 1 bank to freeze the pension account of the petitioner. Full stop. The respondent number 1 bank shall immediately, comma, positively within 48 hours from communication of this order to the respondent number 1, comma, acting upon a server copy of the same, comma, defreeze the pension account of the petitioner and ensure that the petitioner is able to operate the same freely immediately thereafter. No rest to cause.